Kia ora koutou, welcome along. My name is Louise Taylor. I'm the chair of the hearing panel today. Welcome. Really great to see good turnout. Obviously, a lot of interest in the project, and it's great to have you here. I'll go through some introductory things and housekeeping and that sort of thing, and we'll go through how we're going to run the hearing, a bit of an order in terms of appearances. And if you have any queries at all during the hearing, Taryn, who will introduce herself shortly, is your go-to. So she's out. She keeps us all on track. So as I said, this panel has been appointed by Central Otago District Council to hear and decide on the application of Helios to establish a solar farm at 48 Ranfurly Naseby Road. My name's Louise Taylor. I'm a resource management practitioner. I'm based in Dunedin, and I'll chair the panel. I'll get the rest of the team to introduce themselves.
Maria Gary Ray, I'm an independent hearing commissioner based in Tasman. I do a lot of hearings down in this district, so really looking forward to this hearing. Thank you.
Morena koutou, my name is Ros Day-Cleven. I'm an independent commissioner based in Utaputi, Dunedin, and I've got a background in resource management planning, and I'm also very familiar with this district.
I'm Taryn Lyons, and I'm the hearings administrator for CODC.
My name's Karen Smith. I'm also a hearings administrator for CODC.
And I'm Adam Vincent. I'm the reporting officer for CODC.
Thank you. Karen, do you want to do a health and safety?
Yes, I do. So just a couple of things. So for fire exits, we are out the front door and we meet on the field just here for any kind of emergency. So obviously we just calmly out the door and onto the field. And I do just have a couple of other points. There is a clipboard up there for anybody that is just in attendance. If we could all just sign in, just so we have an idea of everybody that is here. There are also QR codes around for anybody wanting access to any of the documents. So just scan with your phone and your camera, and if it does ask you to log in, just say open in browser. You don't have to sign into anything. You can just say open in browser, and that will give you all of the documents kind of in live time. If we have anything, it'll be all uploaded into there. The Wi-Fi password is just behind you for anyone needing to log in. And if there is anybody that doesn't have a phone or can't access it on their phone, we do have a couple of iPads there that we can get you access on. So just come and let me know if you have any problems getting in or needing access to any of the documents.
Thank you. So we have read the papers in advance. We've read the application, including all of the submissions. We don't need them read out to us. Thank you very much to all those who prepared that material. It's very, very helpful. Our goal today is and for the next few days, is to understand the application, understand the impacts on the community and the environment, and make the best decision we can. And all of you are part of that process. So thank you for your contribution to that. It's really important to us that we all act in a respectful way. We understand that some people have strong views. That's great. There's no problem with that. But very important that we run the hearing in a respectful way. Things like if there's talking in the back, it's very hard for us to concentrate. So I would ask, if you do need to have a conversation, please go outside and do that and come back in, because it's a sort of a space that we're really trying to lock in and understand the presentations in front of us. So thank you for your cooperation with that. If you have pre-circulated evidence, thank you for that. We have read it. And so we would just ask that you read your summary and any high notes, anything you'd like to highlight with us. We have got questions for the experts, so we'll run through those. If you haven't pre-circulated evidence, please let us know the matters you'd like us to understand. So again, if you've filed a submission, we have read it. We don't need you to read that out to us, but if there are things you'd like us to know, please run through that when you have your opportunity. We will ask questions throughout the process. That's our role. We will discuss conditions of consent. That doesn't mean we've decided to grant or not grant the application. It's very important for us to understand, if we did grant the consent, which conditions would be appropriate to impose to make sure any adverse effects are managed sufficiently. So that's our job. We'll be talking to witnesses and submitters about the potential conditions of consent. That doesn't mean we've made up our mind. We haven't about whether to grant or not. We had the opportunity to take a site familiarisation yesterday. It was really helpful. We all are reasonably familiar with the area, but we did spend a couple of hours yesterday doing a bit of a drive-by on public roads. Really useful to get a sense of the scale of the site, the roads surrounding, and some of the properties surrounding. So we have done that. We may want to do a further site visit, probably after the hearing. We'll make a call on that, and we'll talk to you about that if we do need to. For submitters, if you feel that it would be useful for us to view the site from your property or from a particular viewpoint, please let us know when you come and speak, or just let Tara know. That's no problem, and we can arrange that to do that if that's useful. So in terms of how we'll run things, for those people who have that hearings aren't your usual day job, there's no cross-examination. We ask the questions. If you do have something burning that you feel you need to ask, when it is your turn to speak, you can ask me and I'll decide whether it can be asked to one of the staff or to somebody else. But that's how we'll run it. In terms of timetable, so we've had a hearing. Thank you to Taryn for circulating that hearing schedule. We will hear from the applicant first, and I'll get you to run through that shortly, Mr. Manhinnick, and then after that we'll hear from submitters. Now, it is possible that we will finish a bit early today, and what I'd like the submitters to think about is if you would rather present this afternoon than when you've been scheduled, then have a think about that, and if we have time, we can hear from you this afternoon. We're not going to rush through things, but also we don't want the hearing to go longer than it needs to. So if you would prefer to speak this afternoon after the applicants had their presentations, then we'll have some time to do that. So happy to be flexible. If you'd rather stick with your timetabled spot, that's no problem, and we can do that tomorrow. In terms of submitters, there's a couple of things I just wanted to think about, and I'll get you to talk to Taryn about this as well. That relates to some appearances that seem quite similar to each other. And in particular, Real Dog Company, Rose Voice and Nigel Voice. I'm not sure if they're here. Yes, great, thank you. I see we've got a few slots for you in the hearing timetable. If you'd like to just do that all together, that's fine by us. We've read the submission. We don't need to hear the same thing more than once. So, oh, fantastic. Excellent. You're all over it. Great. No, that's no problem. And the other one is Richard Smith and CJ Sinclair Limited. Are they here? No. Okay, that's fine. Karen, you might just want to check with them if they would like to just present together or not. That's no problem. Okay, I think that's everything. Is there any procedural matters that anyone would like to raise? Start. Oh, you're good. No, fantastic. Thank you. Yes. Is everyone able to hear me all right? No, we've got some shaking of heads, struggling. I wonder if we could, I'm actually quite warm in here. I don't know how you guys are feeling. Maybe we turn the heaters off for a bit and that might help. I've got quite a loud projecting voice. So if you can't hear me, I'm a little bit worried you'll struggle to hear some of the other parties. I'm really comfortable. If you want to move your seats closer, that's completely fine. It's really important that you can hear. You could come around this side. There's no issue with that at all. So just if you need to come a little bit closer, that's fine. And I would just ask anyone presenting, you're talking this way, and often behind it is quite hard for people to hear when we haven't got microphones. So please just, if you're struggling to hear, pop your hand up and we'll see if we can deal with that. But I would encourage you to come forward if you are struggling.
Yeah, because the media table doesn't need to be there, is it?
No, well, it appears we don't have media. So as I say, we could certainly, well, I wonder just actually, why don't we do that now? Why doesn't everyone just move forward just so that we can, Excellent. All right. So in terms of timetable, we do have some possible sort of break times. I'll just make a call about when we need to break. Hopefully, Mr. Manhattan, we don't have you all the way through to morning tea, but you never know. No disrespect. We might get hopefully one of your witnesses in before then, but we'll take breaks when it seems appropriate. And yeah, I think that's over to you in terms of if you'd like to introduce your team and let us know how you plan to run things. Could you just run through the order as well, so we know you're planning to do? That's great.
So good morning, commissioners. My name is Daniel Manhinnick, counsel for Helios. I have Ms. Espin alongside me. As far as the rest of the applicant team, we have next to me Mr. Schlichting, who will be the first witness for Helios. Also representing Helios today is Ms. Brooks, who is here. And then as far as the various witnesses, and this is the order in which they will appear as well. So we have Ms. Sivright, Dr. Morris, and Ms. McManaway. We'll then have two witnesses appearing remotely. So that is Mr. Ibbotson in terms of noise and Mr. Logan in relation to glint and glare. We then have Mr. Denise and Mr. Copeland, and then finally Ms. Bunheady. And so that is a Helios team.
Great, thank you.
And so there have been statements of evidence filed by all of those witnesses. The intention is essentially for all those witnesses to just speak to their executive summary and any other particularly noteworthy points from the evidence. There hasn't been any submitted evidence or any other key developments since the evidence was filed, and so we didn't want to burden you with a whole lot of additional paper.
Very much appreciated that, thank you.
So that's the plan of attack.
Great.
And so with that, I might get into the legal submissions.
Thank you.
And so these were filed a week or so ago, but I do intend to take you through a number of the key points in those submissions as necessary.
Are you happy for us to ask questions as you go through?
Absolutely.
I think we've all got a few questions, so yeah.
That sounds good.
Great, thank you.
So New Zealand urgently needs more renewable energy. Climate change is the defining issue of our time. We need to decarbonise our economy and transition to a more sustainable energy system. Demand for electricity will be sustained by the drive for decarbonisation. New renewable electricity sources will be required to meet these demands. Developing and consenting additional renewable generation capacity across New Zealand is critical for a stable future. Solar energy will improve electricity generation capacity and play a critical role in New Zealand's energy future. One important advantage of solar energy is that it mitigates the risk of insufficient energy supply during dry years, where hydroelectric schemes have lower electricity production. And so that's one way that solar supports energy resilience. Large-scale solar has the lowest visual and environmental impacts of any renewable technology, can be deployed quickly and complements agricultural activities. It will therefore play an essential part in meeting the government's goal of doubling renewable energy in New Zealand by 2050, alongside the commitment to net zero carbon emissions by 2050. It's a form of energy generation that's fundamentally compatible with the significant agricultural components of New Zealand's economy. Helios is a leading New Zealand-based solar developer and is well placed to facilitate the development of additional solar capacity to assist in New Zealand's climate change response. It seeks land use consent for a solar farm at 48 Ranfurly Naseby Road. It has undertaken a comprehensive site selection process across New Zealand to identify the site as part of a portfolio which meets suitability criteria for a solar farm. And I'll return to those selection criteria in a little bit further detail later in these submissions. Site is an ideal location for large-scale solar. So you would have seen in Mr. Schlichting's evidence that Maniatoto Plain has strong solar resource. This means more renewable electricity can be generated from each solar panel than would be possible in most other parts of New Zealand. The site's also a large flat area, has suitable geology, does not contain any map constraints such as ecological, heritage or cultural overlays, and has a proximate, technically feasible grid connection to an unconstrained part of the transmission network. Project will consist of approximately 550,000 solar panels mounted on a tracking system with associated supporting electricity infrastructure, a substation and underground transmission line infrastructure. Project will have numerous benefits for the local community and New Zealand. It's expected to provide enough clean renewable energy to power the equivalent of approximately 70,000 homes annually. This represents a significant contribution to New Zealand's renewable energy targets and the decarbonisation of our economy. From a planning perspective, the project aligns with the relevant planning framework, including the objectives and policies of the district plan, the various RPSs. It also aligns with the objectives of the NPS for renewable electricity generation, and is consistent with the National Policy Statement for Highly Productive Land. The effects of the project have been assessed and addressed by Helios. It's proposed a comprehensive mitigation package that results in the long-term effects of the project being less than minor. About 180 submissions were received on the project. A number of these were in support, while other submissions raised concerns with the project as proposed. Many of these related to the aesthetic values of the area and various potential environmental impacts, such as glare effects from the panels. Helios has carried out a transparent consultation process with stakeholders, the community and mana whenua groups. It has considered, and where realistically possible, incorporated submitters' concerns. And the most notable example of that is the removal of the BESS, so the battery storage system that has been. That is a significant concession. I also make the point that no submitted evidence has been filed, or no expert evidence. Helios has carefully reviewed the proposed conditions put forward in the officer's report, which does recommend that consent is granted, and there are very few issues that do remain between Helios and the reporting officer on the proposed conditions. In our submission, the project should be granted consent on the conditions as contained in the evidence in this part heading. I'll take 1.13 as read.
Okay.
In terms of the site, 665.1 hectares leased for the site, comprised of land located within 6 land parcels of unirrigated farmland owned by 2 local farming families, situated between Ranfurly and Maysby, as you would have seen in your site visit yesterday. It's currently used as pastoral land for livestock grazing. The surrounding area is predominantly rural, with some industrial activities, including the Kiwi Space Radar and Transpower substation in close proximity.
Can I just ask a question? The 2 landowners, are either of those submitters on the proposal?
Question. I'll come back to you on
Back
that.
to me on that, thank you.
The site meets the criteria that Helios applies when assessing the suitability of sites for solar farms. And so at 2.3, go through those various points. Now they, again, will come back to in the context of functional and operational need. We'll come back to that in the context of commercial study. So the project consists of the solar panels mounted on a tracking system, 73 inverters, and the construction of a substation near the existing Transpower substation. The panels will be mounted on a single axis tracking system, aligned in north to south rows, which will slowly rotate to follow the movement of the sun throughout the day. Panels will have a footprint of approximately 20.5% of the total site at their maximum site coverage. And that's less than, in the officer's report, it talks about it being 23.3%. That has been reduced with the removal of the BESS, for example. So it is now 20.5% site coverage. Pasture will be maintained across the site with concurrent shed grazing around and underneath the solar panels.
So a question on that, whose evidence covers the extent that grazing can continue?
So that is, there's certainly commentary on that in the officer's report. From a Helios perspective, there is some commentary in from Mr. Schlichting as far as the arrangements that Helios has here and from experience with other sites as well. So he can certainly talk to that.
Okay.
And then there may be, depending on the particular question you may have, there could be other witnesses who might be able to assist with that too.
We note that, just as a heads up, we note that that's mentioned as a theme through quite a number of people's evidence, but haven't really seen what that's based on. So it'll be useful just if you need to come back to us on that, or Mr. Shipton may well be able to answer that. And then the follow-up sort of question, just so you're aware and your planner might be able to deal with this, is how relevant is that in terms of the NPS, HPL, RPS and district plan objectives and policies, and how important is that for us as a decision-making factor?
Certainly.
Thank you.
At 2.6 addressed the urgent need for more renewable energy infrastructure and Transpower's forecast for the additional energy demands that New Zealand will have by 2050. Section 3 of my submissions address the changes that have been made since lodgement. So at 3.2, the removal of the BESS. So that is a significant concession from Helios's perspective. That's been addressed in the evidence of Mr. Schlichting as far as the rationale for removing that component. But despite the removal, it does remain commercially and technically viable. Without the BESS, it's not an essential part of the project in order for it to progress. That removal has also resolved the Otago Regional Council's concerns, and so that has been communicated from the Regional Council to the panel.
Yeah.
There were concerns raised about fire issues in the reporting officer's report, and so there has been ongoing engagement with FENZ. As a result of that, FENZ has now confirmed in writing that it considers the proposed fire risk mitigation measures and draft fire management plan conditions are acceptable to it. The site layout has also been updated to include a new 4-metre wide perimeter access track to allow more comprehensive firefighting appliances access around the site and to provide additional fire break as well. That is supported by FENZ, and again, that's been communicated directly by FENZ to the panel.
So on that, we can ask Mr. Denise about this, but the attachment 1 to his evidence is an email train.
Yes.
From Bobby Lamont at Fire and Emergency. It does appear that there looks like there was still an ongoing discussion from my read, but he may be able to talk to that.
Certainly, and I think Mr. Denise will be the one
Right.
able to address
Thank you.
Another key area of ongoing engagement has been in relation to ecology and the concerns the Department or the Director General of Conservation had. So there has been extensive discussions between Helios and DOC that have resulted in agreed avifauna conditions. And again, DOC has tabled a letter to confirm that it is supportive of those conditions that have been proposed.
Okay.
And then a further change that has been made, a number of submitters raised concerns in relation to the construction vehicle access route. And so you would have seen that in Mr. Copeland's evidence, rather than the original proposal, which was to avoid Gough Road, it's now that position from Mr. Copeland that Gough Road should be avoided is now no longer part of the proposed conditions, and so that does provide optionality as far as vehicle access. I briefly in section 4 touch on the legal framework. I don't intend to take you to that, but very happy to answer any questions you may have.
Thank you.
On your question about the landowners and the submitters, yes. So neither of those landowners are submitters.
Okay, thank you. That's very helpful. In terms of the effects, I wonder whether we're better to hear from the witnesses about those. So happy for you to move through that, unless there's anything particular you think from a legal perspective is useful.
In relation to landscape and visual, one of the, well, it is accepted that there will be some effects in the short term at the construction stage, but the evidence in this McMahon way is that that becomes less than minor over time. From a legal perspective, it's just reiterating that effects being less than minor isn't a particular threshold that needs to be determinative of whether consent is granted or declined or what the proposed conditions need to be. So there can be situations where there could be even significant effects, but on an overall basis, an application is deserving of consent. We're certainly not in that category here as far as the level of effects, but particularly if we're talking about short term, you don't need to be fixated on whether the effects with mitigation will be less than minor or not. It's not a particularly relevant threshold. It is that broader assessment and consideration of the objective and policy framework and the like that is relevant for your decision making.
Thank you.
In terms of glint and glare, so Mr. Logan's assessment was primarily focused on sunlight. There were various concerns raised in terms of moonlight as well, and so there is an attachment to Mr. Logan's evidence that does address that, and you'd have seen the orders of magnitude difference between moonlight versus sunlight and why that wasn't considered to be an issue here at all. On fire risk, the evidence of Mr. Denise addresses those various issues, again reiterating that FENS is happy with the proposed conditions, and Mr. Denise can take you through that. On terrestrial ecology, we do have a situation where there are areas on the site that are that meet the definition of natural inland wetlands. I'm sure the commissioners will all be aware that those definitions are very broad as far as what might be captured, and just because something is captured as a natural inland wetland, that doesn't necessarily correlate to that being a high value wetland. And so Dr. Morris will be able to take you through that there has been the standard orthodox process adopted as far as identifying which areas meet those definitions. There is a separate consideration of what the value actually is, which is relevant again to what conditions might be proposed. One of the key issues relates to what the appropriate setbacks are, and so we'll take you briefly to that.
Thank you.
I just have one question on that, Mr. Is the NPSIB relevant, especially clause 316, which deals with areas outside an SNA? In your submission, is that something we should consider, the effects management hierarchy, for instance?
From my perspective, we don't have any SNAs identified anywhere in proximity to the site. It is, I will reflect on that particular provision and come back to you on that point.
Yes, just to finish that off, it's clear there's no SNA, but where a site meets the criteria for being an SNA, that does kick, the NPSIB kicks in at 316. So
yes,
Dr. Morris might be able to help us with that, but we just need to know whether we should consider the legal ramifications about that. Yeah.
Indeed.
Okay, thank you.
So at 519, irrespective of the value of these various wetland areas across the site, the proposal is to avoid all of them and to have a setback from them as well. What is proposed is a 10-metre setback from the two larger wetland areas and a 5-metre setback from the smaller wetland areas. Now, Dr. Morris in his evidence suggests that there is a clear ecological basis for why those particular setbacks have been selected. And so from an ecology perspective, there's a clear rationale as to why those different setback distances have been chosen. Also, and you would have seen in Mr. Schlichting's evidence, there are commercial impacts. So there's the ecological side of things, but also the larger the setback, it does result in the loss of panels, therefore loss of generation and reduction in the benefits arising from the proposal. In the officer's report, there is reliance on the NZ Rail decision and suggests that because in NZ Rail it said it's not for a panel to decide on whether a project is viable or not as far as challenges to overall project viability. Therefore, none of those reasons as to the impacts on the consent holder or the project of a different setback are relevant. Now, my submission, those are clearly matters that you should be considering. It's not purely a question of in a vacuum looking at what the setback is. There is well-established case law, and you have section 108 as well that talks about the need for conditions to be reasonable, for example. That whole question of reasonableness has to bring in broader considerations than just looking at it through a pure ecological sense. And so those factors are relevant. But reiterating again, Dr. Morris has been clear that even from a pure ecological perspective, 5 metre setback from those smaller wetlands is all that is necessary from an ecological perspective. And so both Dr. Morris and Ms. Barnheady will be able to talk to you about that.
Stop you there, ask you a question. So in terms of you were probably getting there at paragraph 5.23 around the NESFW. Is there a reason why the application wasn't lodged with the ORC at the same time to ensure that integrated consideration of the setback?
It was one that at the time, so Helios's experience has been that where they have been progressed at similar times, there can still be a disconnect as far as where things get to as far as detailed design. And so there has been engagement with the regional council. There has been essentially a pre-act type process, but it was seen in the context of this particular application that it was more efficient to move through with this consent application. And following this and the outcomes of that, and as the detailed design moves on, then the regional consenting can move through. The regional consenting may well be non-notified, given that the impacts are localised within the site, for example. And so that is a separate decision-making process. We certainly understand that. But for those reasons, Helios made the decision to just progress with the district council consenting at the stage.
On that, Mr. Manhinnick, is there any issue for us in terms of, a sort of any sort of concern from our decision-making point of view around not having the full understanding of potential effects in terms of regional matters and the general sort of expectation that, the sort of bundling idea we need to have a full understanding? Is there any legal risk that separation?
In my submission, it would be almost the opposite, in that firstly, there's no dispute that all the effects aren't on the table. And so you do have a comprehensive ecological assessment before you. So you don't have a concern that there are effects that are out there but aren't that haven't been assessed through this process. The other aspect is that there is still a further consenting process down the track, and so therefore another degree of scrutiny at that point as well. And so you don't need to feel that this decision making either is the only opportunity for those issues to be considered, nor is this determinative of what that outcome is. And so we've also been clear that if a more restrictive setback ends up being imposed through the regional council process compared to this, clearly that more restrictive setback has to apply. So it's not a situation where it's essentially a lowest common denominator as far as Helios as the consent holder, should consent be granted by the two councils, has to comply with all the conditions. It can't pick and choose which ones it wants to comply with.
So if there was a situation whereby, say we granted the consent subject to the conditions being proposed by your team, or a variation of those, and then ORC imposed a tighter restriction around wetlands, then the viability, does that, and say that affected, well, I guess, is there a risk that that therefore affects the viability of the project? Would that be a case then? It would simply be they couldn't, Mr. Shipman couldn't proceed with his project because of the regional council consent, even though the district council consent had been granted.
Correct. So just like any other consent holder, once they've had their consent granted, they've got to just make a decision whether to proceed or not. Helios, assuming that consent were granted by this panel, and then subsequently any regional consents were obtained as well, it would be for them to look at those various conditions and make a decision as to whether to proceed or not. In relation to avifauna, those are the matters that have resulted in the agreed conditions with DOC. From a legal submission perspective, just wish to reiterate the evidence that Ms. Sibright has provided about the real paucity of evidence that suggests that this could be an issue. And so in my submission, it is a highly conservative approach that has been taken to make sure that those concerns, should they ever eventuate, are appropriately managed and avoided and mitigated through those conditions proposed. And it is essentially an issue that's arisen because of the large-scale solar as a sector being fairly new, and so there not being lots of examples in the New Zealand context. And so that's why you would have seen the literature review that's discussed includes a lot of Australian research, for example, and other overseas locations. And so it is a very conservative approach that has been taken to those issues. I'll now hand over to Ms. Espin, who will just briefly take you through transport and acoustics and positive effects.
Thank you.
In relation to the transport effects, Mr. Copeland has deemed that these will be acceptable, and there are no notable adverse effects relating to road safety or efficiency, and there are no outstanding issues between Mr. Copeland and the reporting officer. Mr. Minhinnick has already briefly gone through the reassessment and change in Mr. Copeland's view in relation to the use of Gough Road for construction vehicles. So now there is the option to use both, which opens up a route to avoid going through Ranfurly itself. And that was in response to submitter concerns and questions raised in the submissions. A number of more general concerns raised by submitters have been responded to in the evidence of Mr. Copeland and will be addressed in further detail in the construction traffic management plan. In respect of acoustics, again, Mr. Ibbotson, who will appear online later throughout the day, has assessed both the noise and vibration of the effects during both construction and operation of the project. He considers that the project can comfortably comply with the district plan limits in both the construction and operation of the project. Again, there's a high level of agreement between Mr. Ibbotson and the reporting officer in this case. There is one outstanding issue which relates to the appropriate construction limit, noise limit to apply. It is the typical versus the long-term limit, and there's a 5 decibel difference between the two. But as Mr. Ibbotson will explain, the project comfortably fits within both of those limits, so it isn't a substantive issue in our view. The reporting officer has also noted his preference for monitoring of construction noise for pilot. However, Mr. Ibbotson is clear that because there is compliance within the limits by such a large margin, so around over 20 decibels in both the construction and in this case, the operation, there is sort of little utility in undertaking such noise monitoring because it isn't close to those limits. And although the reporting officer does agree with Mr. Ibbotson that the operational effects will be so sufficiently low without any additional attenuation or mitigation needed, he states that if the panel are minded to disagree, acoustic fencing could be implemented. Mr. Ibbotson doesn't agree that any additional noise control fencing is required, again, given the very low noise level from the transformers and the fact that it isn't anywhere close to those limits. In terms of, if I can just move on to positive effects, as Mr. Minhinnick has identified at the start of this presentation, the project has significant positive benefits. It will make a major contribution to the demand for renewable energy and New Zealand's goal to achieve net zero greenhouse gas emissions by 2050, with the government aiming to double renewable energy by 2050. Mr. Schlichting will identify in his presentation that there will be significant investment in the region, around 450 million, and a large number of employment opportunities, particularly through the construction phase of the project. There were also, I'd just like to point out, a number of submissions that were raised in support of the project. So identifying benefits such as job creation, bringing new technology and skills to the area, and a diversification of economic opportunities beyond economic effects. Some submissions noted the genuine need for more renewable energy. The project will be a cost-effective, low environmental impact, high production method of increasing renewable energy nearby to the existing substation.
And so moving on to the planning framework, don't intend to address that in detail. A few observations from a legal perspective. The NPS REG, the strong alignment with that document. I outline at 6.5 the guidance that it provides for decision makers. And then at 6.6, Ms. Bunheady's planning evidence about strong policy support for renewable energy through that document. Also note the recent changes proposed to strengthen that, although those changes haven't taken effect, so aren't considerations for you. They, more from a broader perspective, signal the direction of travel in that respect.
Is it intended, is it in the package likely to come through by, say, December?
Correct.
This year? Yeah. So hopefully our decision will be up for then.
Indeed.
Yes.
At 6.7, I have addressed the NPS HPL, and I will just speak to this in a little bit of detail. So there is a very small proportion of the site that is identified as LUC3. So the National Policy Statement for Highly Productive Land classes LUC 1 through 3 as highly productive land. And so there is then a regime within that national policy statement that applies for considering applications for resource consents as well as plan changes and the like that do address highly productive land.
Just a moment.
Showing the hard land. Yeah, just checking whether there's somewhere in the plans that identify that highly productive land.
I wonder.
I haven't got it in front of me.
Whose evidence is that in?
It was
Within
certainly
the
the application
application.
material, I
Yeah.
think.
Yeah,
So, it checked as far as its location to assist you with that.
Yeah, just,
I can,
oh, that'd be great. Thank you. Oh, we've got it. Excellent. So that's Which
Yeah.
is the
What part of the site is it?
So we're looking at this one.
Yes.
What, do you want to just help us out with
With which is the
highly productive, which is
the
OUC three?
max inventory
Yes.
scheme.
What part of the site is it? Just generally,
Just generally,
just generally, what part of the site is it? Is it central or?
No, it's the it's the sort of orangey colour, so the
Yeah.
bottom.
bottom right, southeast,
Yeah.
little portion. So just for those in the room, we're looking at figure 2 from the application documents. And we're talking about this little piece. Yeah, okay. Thank you.
And sorry, and then a small portion in the
Oh,
northwestern.
Northeast.
Little-
Oh, yeah.
Yeah,
It's probably for that one.
Yes. Thank you.
okay, it might be useful to show the actual plan of the solar panels as well, because they don't go into all of it. Some areas of it.
That's fine. That's useful. Thank you. Thank you.
Now, importantly, the national policy statement in 3.91 says territorial authorities must avoid the inappropriate use or development of highly productive land that is not land-based primary production. But then in 3.92 identifies a number of exceptions of activities that aren't inappropriate. Importantly, this includes one of the following, where there is a functional or operational need for the use of development to be on the highly productive land, which includes the development, operation or decommissioning of specified infrastructure. And then renewable electricity generation fits into that definition of specified infrastructure. And so that exception applies where there's a functional or operational need for the infrastructure to be located on the land. Now, in terms of functional and operational need, the officer's report with respect is a little bit unclear as to the officer's particular position. It talks about functional need, but it's not clear whether that is saying that there isn't any functional need or operational need, or whether it's accepted that there is an operational need. Importantly, it's only one of those two needs that needs to be met for the exception to apply. In our submission, both functional and operational needs exist here. This question of functional and operational need has been considered in a couple of recent decisions by the Environment Court. And so happy to make these available, or in my reply I can address them, but there's Meridian Energy and Tararua District Council, which was a wind farm proposal, and there the Environment Court was satisfied that the quality of the wind resource and the proximity to the national grid meant that it did meet that requirement. Importantly, those weren't considerations that were unique to the particular site, but it was that general location. And so that is, when you look at the reporting officer's discussion of functional need, there seems to be an acknowledgement of functional need in the area, but not specific to this particular site. Now, from a legal position submission, we say that where the reporting officer has got to, as far as the acknowledgement of those various functional need factors, do mean that those functional and operational need tests are met here. And so that is important as far as how you work through the national policy statement for highly productive land. Importantly note though, even with the reporting officer's view about functional need, he still reaches the view that it does still actually satisfy the overall policy direction within the national policy statement. Now, the other recent decision from the Environment Court is on the next clause. So 3.9 is the clause that deals with the exceptions. 3.10 is then the general requirement to minimise or mitigate, 3.93 is about the requirement to minimise or mitigate any actual loss or potential cumulative loss. And that's of the availability and productive capacity of highly productive land. So in that respect, the fact that the use of the site as a solar farm is complementary to potential use for grazing by sheep is a factor that goes to it still being available for some productive uses. It doesn't say highly productive land has to be used for highly productive purposes. It doesn't compel a farmer to use his or her land for the highest possible use or the most productive use. It is about the availability of it. And so therefore, perhaps going back to your question earlier about all the detail around what the grazing might look like, it's not so much all of those details as the fact that it remains available for that particular productive use. And so that, from our perspective, helps address this question of mitigation of any perceived or actual loss of availability through use for a solar farm.
And does that also include your decommissioning? Does that become an important factor as well, the decommissioning?
Correct, because
reverting back to pasture.
Because that's, and I was going to come on to this as far as briefly touching on some of the conditions, but the term, it is reasonably unique in the context of a land use application for a specific term to be proposed. We'll touch on the details around the drafting of that for that condition, but it is for a particular life, the life of these solar panels. It is proposed to be decommissioned at the end. The land will essentially all be able to then be returned to productive use as far as where all the panels are.
Yep. And finally, if you can give us those two cases you mentioned, because I did have a question about how high was the bar for determining what the need is. Does it have to be a unique site? Does it have to be right alongside? And you have answered that in your legal submissions, but we would like to see those cases too.
Absolutely.
Thank you.
And so it's Meridian Energy in Tararoa, and then the other one is CJ Industries and Tasman District Council. And that is where the court said it was too rigid to say there can be no loss of availability or productive capacity, that the framework within the national policy statement clearly contemplates that there will be a degree of loss, but provided you follow those various steps as far as minimising, mitigating those effects, then that is sufficient. And so I'll provide copies of both.
Could you cover that in your reply?
Certainly.
Yeah, great.
Thank you.
That's
fantastic.
And then I briefly touch on the RPS and district plan. Ms. Banhidi will take you to those in more detail, but just the alignment between Ms. Banhidi and the reporting officer in respect of those. In terms of conditions, just wish to briefly address a couple of them. So there is a significant degree of alignment between the respective planners in relation to conditions. I discussed earlier the need for conditions to be proportional and reasonable. I'll again be able to provide authority if it would assist on that point.
No, that's fine.
And so that does arise, particularly in the context of the wetland setback. But the two other conditions I wish to address, firstly, term. And so there, Helios has been keen to ensure that it has walked the talk essentially as far as its engagement with the community that has said we have a 35-year lease term. Panels that reflects what the life of panels are, and so we are only seeking consent for that duration. The reporting officer translated that as it is 35 years from commencement of the consent. Now, importantly, as far as the way that those arrangements are structured, it's 35 years from essentially once the panels get turned on, and so that's why the conditions proposed by Ms. Banhidi include some changes to that condition to make sure that it's not shortchanging, so to speak, the operational life of those of the panels as far as what has been consented.
Yeah.
The other aspect that has come up is the reporting officer's proposed conditions 35 to 43, which are about a bond. So this is one where there are conditions that require the decommissioning and a question of whether, in addition to those, there needs to be a bond to provide additional comfort to the council. You would have seen Mr. Schlichting's evidence outlining that there are already bonding requirements through the property arrangements in place that require or that provide certainty to the landowner as far as that occurring. Ms. Bunheedy addresses this in her evidence as well, as far as going, is there any environmental benefit arising from requiring essentially what would in practice be a whole second set of bonds to be issued in relation to this project? And so the evidence of Ms. Bunheedy and Mr. Schlichting do address that issue. Again, it's one that we don't see there being an environmental benefit that corresponds to what it ends up being a material cost over the life of the project as well. So those.
Thank you. In terms of the suggestion that a bond isn't required, does that not present for the regulator a significant risk in terms of if any condition was to be breached? How can a community have certainty if the regulator does not have that certainty in place via a bond?
It is, in terms of the range of resource consents that are granted by councils up and down the country every day of the week, it is incredibly rare for bonds to actually be required. And so as far as when it comes to a housing development or a range of different activities, it is rare for bonds to actually be required. In terms of solar projects across New Zealand, again, it is incredibly rare for bonds to actually be required. And so there is a suite of conditions that any consent holder needs to comply with. There are then a range of enforcement powers that councils have in order to ensure compliance with those conditions of consent. That is the most orthodox, routine, everyday approach that is taken to compliance with consent conditions.
Would you accept in large infrastructural projects? They might be more common.
Certainly more common, but I wouldn't say that they would be. They are more common than in smaller projects, but I still wouldn't consider that they are common in the general sense. So in my submission, it is that it is unusual for bonds to be required.
And just following on from that, if there was a situation where the project gets halfway through, the consent at that point, consent holder runs into financial trouble, what certainty does the council community have that the site would be remediated?
Certainly. So that is addressed in Mr. Schlichting's evidence, and so he's probably the best one to speak to that as far as how the development of solar projects occurs. The timescale, which is the most precarious from a solar developers, is this right at day one, essentially. And so when you're trying to get the funding to actually get the project underway, it's a situation where the capital investment is all at the outset rather than over the life of the project. And then Mr. Schlichting also addresses as far as the economics of decommissioning as well. And so he can take you through that in far more detail than I can.
Thank you. And just finally, though, on that, just to foreshadow, I note in Mr. Schlichting's evidence, he's talked about a lease arrangement with the property owner. That's nothing to do with us, though, isn't it? In the sense that from a consenting perspective, we have no control, or the council won't have any control over that. So is that a relevant consideration for us?
It is insofar as the impact on the consent holder, as far as that there are already bonds that are in place. But certainly, as far as the flip side of it, as far as the level of comfort that a regulator may have, we certainly accept that the regulator isn't a party to those and can't have control over those.
Yes.
That is acceptable.
Thank you.
So those were all the matters I intended to take you through. Very happy to take any further questions you might have, but otherwise I can get into first witness.
Thank you. And we're perfectly on time. Great. We'll carry on. No problem. Thank
So
you.
first witness is Mr. Schlichting.
Thank you. Welcome.
Thank you. Tēnā koutou katoa. Good morning. My name is Jeff Schlichting, and I am the co-founder and managing director of Helios Energy and director of Helios OTA Op LP, the applicant. I have over 35 years experience working in renewable energy across North America, in East Africa, and more recently in New Zealand. My professional experience includes serving as either the lead developer or as a lead advisor on more than 4 gigawatts of renewable energy capacity now in operation, primarily wind and solar. The cumulative capital investment represented by these projects is approximately 10 billion Kiwi dollars. At Helios, over the last 5 years, I have been leading the development of a 1 gigawatt portfolio of solar farms across Aotearoa, New Zealand. I have been involved with the Maniatoto project from its inception in 2021. It is one of the highest priority and most advanced developments in the Helios portfolio. I have been actively engaged in all elements of the development, including identifying and evaluating specific site and connection options for the project, meeting with Central Otago District Council, establishing the relationship with Mana Whenua, speaking with landowners and neighboring property owners, and researching the history of the area. Helios is a leading Kiwi solar developer that seeks to create real environmental change by developing large-scale solar energy projects. Helios endeavors to create a positive legacy of a more sustainable future through our work, to contribute and accelerate a zero-carbon future for Aotearoa, New Zealand, and to be a leader in the energy industry by developing state-of-the-art solar farms. Helios has pursued development of this project guided by a strong set of values. Those values are represented by Te Aki, to safeguard, Whakararoi, to provide, Hononga, to connect, Kaitiakitanga, be guardians, and Whakamanawa, to inspire. Aotearoa, New Zealand requires significant investment in renewable energy to ensure that we have abundant and affordable electricity, while also meeting national commitments such as net zero carbon emissions by 2050. Transpower forecasts that Aotearoa, New Zealand will require 70% more energy by 2050, which is roughly the equivalent of a new Clyde Dam being built every year for the next 25 years. For context, the projected annual output of the Maniatoto solar farm equates to roughly 1/3 of the Clyde Dam's annual output. Given this need, it is clear that all regions across the country will need to accommodate renewable energy projects. Solar energy, and particularly transmission-connected projects of scale, will play a crucial role in phasing out current fossil fuel generation and providing the new electricity generation capacity that the country desperately requires. Solar energy has a range of benefits that sets it apart from other renewable resources. Those include being most productive in the summer months, which allows water to be retained in hydro lakes for use during peak demand periods, particularly in winter. It is quick to deploy compared to other generation technologies, complementary to agricultural activities, and safe, quiet, and easy to visually screen on sites with flat topography. Helios has surveyed the length and breadth of the Motu to identify potential project sites that can accommodate solar farms that are then connected to the national grid. This land at 48 Ranfurly Maysby Road has been identified as one of the more favorable locations for large-scale solar in the country, and in my opinion, based on a combination of metrics, is the most suitable site for a project of this scale within the Central Otago District. These criteria include characteristics such as adequate solar resource, feasible and proximate grid connection on an unconstrained part of the national grid, adequate and available flat land, suitable geology, and no mapped constraints. This site on the Maniatoto Plain stood out against these criteria as being one of the rare sites that meets all of these requirements and is therefore an excellent option for solar. In addition, the site layout, including additional boundary and internal planting, has been carefully considered to provide suitable setbacks from roads, internal wetlands, and higher sloping, more visible parts of the site. This has all been done with the aim of both screening and integrating the project within the wider landscape. The site's current use as sheep grazing pasture will continue under the panels. I have had extensive involvement ensuring that we have consulted with Mana Whenua, stakeholders, and the broader community. Once site land rights were confirmed with respective landowners and a preliminary project design was prepared, the wider local community was invited to a drop-in event at the Maniatoto Golf Club. Throughout the development of the project, we've sought to continue conversations with nearby landowners, as I've detailed in my evidence. This included arranging for our landscape architects, Papa Miskell, to visit 4 residential dwellings nearby the project and incorporate their findings into the landscape and visual assessment and the planting plan submitted to council. Following public notification and receipt of submissions on the project, I also made the decision to remove the battery energy storage system from the scope of the application. The rationale for this is discussed further in my evidence, but I wish to highlight that Helios' desire to address the concerns and submissions of the public played a significant role in our decision to amend the application. I outline in my evidence a response to the submissions where they relate to the development of the solar project, as well as construction, operation, maintenance, and decommissioning. In my evidence, I spoke to the contractual obligations Helios includes in its landowner lease agreements for establishing a decommissioning fund. The fund covers decommissioning and reinstatement costs based on initial estimates and regular updates by a qualified and reputable third party. Security will be provided via a corporate guarantee from an investment-grade affiliate or a performance bond from a registered bank. While typically established later in a project's life, Helios commits to establishing this security much earlier, from year 6 of operations, which is an industry-leading commitment. I am not aware of any other solar project in New Zealand being required to post a bond as a condition of resource consent. It is on this basis that a bond in favor of the council is, in my opinion, redundant and unnecessary. In response to submitters' concerns regarding the potential impact on the Naseby Dark Sky Reserve, I outline in my evidence our correspondence with the New Zealand Dark Sky Accreditation Delegate and the Moonlight Reflectivity Study Helios commissioned, concluding reflected moonlight from solar panels has a negligible effect on light pollution. I consider conditions have been provided to adequately manage environmental effects for all stages of the solar project's lifespan. I also address questions in regard to Helios, which I confirm is a Kiwi company developing a portfolio of projects exclusively across New Zealand. This project will generate 300 megawatts of clean and renewable energy, all of which will stay in New Zealand, increasing energy supply and resilience. It represents an investment in the Central Otago region of approximately $450 million. The construction period will generate significant jobs and 5 to 6 full-time equivalent local on-site roles during operations over a 35-year term. In addition, the project landowner partners will be able to diversify their earning streams and secure long-term rental while still farming the land. While I generally support council's proposed conditions as worded, I address in my evidence a number of changes that are requested to ensure the project can be practicably and viably brought to market and delivered. Importantly, a discrete number of amendments are requested to reflect the submission of Manawhanua Ka Runaka. Where condition amendments have been requested, for example, the duration of consent and in relation to a bond, these changes are requested to reflect the condition wording we see on other approved solar farm projects across the country. In summary, Helios considers that this is a robust and comprehensive application for a high-quality solar farm. The project will support Aotearoa New Zealand's renewable energy goals with minimal impact on the environment. It is being advanced by a company that is passionate about the process and end result. I respectfully request that the application for the project is granted on the conditions attached to the evidence of Ms. Mishka Banhidi. Ngā mihi nui, thank you for your consideration.
Thank you. You seem to be reading from something there. Is that, are you able to provide a copy to?
I will. I'm happy.
If you just send that through to Taryn, that would be very helpful. Thank you. We do have some questions. Is that all right?
Yes,
If we ask those now. In terms, you've got your evidence in front of you. Excellent. Can I just take you to paragraph 1.4?
Yes.
Great. So in there, you're talking about a site layout and additional boundary and internal planting has been considered. The internal planting that you're talking about there, is that the planting that's been recommended by Bokama School and shown in the graphic supplement in this?
In the
Set of-
landscaping.
Yes.
Yes.
So you're familiar with that generally?
Yes.
Yes, don't worry, I won't quiz you on it. I'm just, what I'd like to know, do you have an understanding of the kind of scale that's been proposed and I guess the number of plants or how much that will cost to impose, to actually deliver on?
I do not know those numbers off the top of my head. We can provide those to you. I think our landscaping expert can provide those more directly.
So my interest from you is not so much how much is it, but do you have a sense of how much it is? So that, and are you confident that that is well within your budget for this project? Because it's a significant, I mean, we visited the site yesterday, it's huge.
It's a
And the amount of planting that would be required to implement the mitigation plan will be significant.
Yes, we are acutely aware of planting requirements on this project as well as others.
Yes,
They easily exceed $1 million, upwards to $2 million. It is not only the cost of the planting, but the effort in securing planting from the nurseries, making sure those plants will be available. Our comprehensive planting plan and budget that goes with that is part of the pro forma economic analysis that we did. And so our senior planning director is constantly working with our advisors, in this case, office, to keep a budget of that and incorporate that into the project budget. So yes, that is part of the project budget. Again, and in broad terms, the anticipated budget for this project would be $450 million. So while not inconsequential, it is a large budget.
thank you. And in terms of your other projects in New Zealand, is this one the most far advanced? Did you say have you constructed any others?
We have not constructed projects yet.
Yeah.
We have a number of other projects that have secured consents and are at a similar stage, moving into more detailed design and finalizing our connection. In the development process, consent and the connection to Transpower often go hand in hand or on a parallel path. Both are fairly lengthy processes, as you're familiar with consenting. the connection process for TransPower is a multi-year process involving application, investigation studies, et cetera.
So you've consented some, how many?
We have secured consent for 3 sites? 2 sites.
2 sites?
One is under decision at the moment, and this is a fourth that we're in process.
Okay, so 2 have consent, 1's been through the hearing and you're waiting on decision?
Right.
And
The
then you have
hearing
consent.
hasn't closed
Oh,
technically yet.
okay, you're in a similar stage as this
Yeah.
one? Yeah, okay, thanks you.
Yes, our Helios's reply has been provided a week or so ago, but waiting for close of that hearing.
Okay, thank you. Guys, I'll keep going. Thank you. In paragraph 6.8.
Yes.
You've talked about that there are some concerns raised by submitters that, you know, why would we build a whole lot of renewable energy here when the demand is in the North Island? Primarily, that's the general premise, I think, of some of the submitters' concerns. You've talked about the switch that will need to happen from industries that process coal or use coal. And you've talked about at about the middle of that paragraph, you've looked at the EECA data, and it shows that while the South Island demands only 12% of New Zealand's processed heat energy, it consumes 84% of New Zealand's processed heat coal demand. Do you have a understanding of what that generally is made up of, or are you just
It's primarily dairy processing, and so that is the dairy industry is the largest coal-fired industrial process on the South Island, is my understanding. In addition to conversion of that to electricity-driven industrial process, there is significant interest, for example, with the smelter, New Zealand aluminum smelters, in opening an additional plot line for their facility. There is interest in data centers in the far south for a variety of reasons. And so I think in terms of the growth that the country is anticipating in electricity demand, it's not all going to happen in the North Island. I mean, Auckland will continue to grow, but industry elsewhere, particularly here on the South Island, there is a push for greater demand to make it an attractive opportunity for establishing industry, establishing jobs, building out current sectors, improving the emissions profile of current sectors. So I obviously disagree that all of the energy will be flowing north to the North Island.
And at 6.13,
Yes.
the second sentence, you've talked about, third sentence. Just reminding myself what this. You've got your annual district funding that you've talked about there, that you're offering. Annual funding commitment of about 140,000 per annum, excluding escalation. And then you've got a cumulative contribution of approximately 7 million. Is that what period is that over? Is that the 35 years?
35 years.
Yes. Yeah.
I had a question on that paragraph too.
Yes.
In terms of the sponsoring, the funding initiatives that you've mentioned at that paragraph, could you explain the funding levers, how that might actually occur, how those intentions would be realised?
Yes, well, our intent is to make it a meaningful contribution to the community focused on these 4 areas. And what we envision is a trust represented by the local community, perhaps district council, by Mount Funawam and by a project Helios representative. And applications would be submitted to say, this is a use for the funds we would like to request, and it fits largely into one of these four categories. We don't want to be rigid about it. We don't want to try and dictate what a particular community's needs are. We think these are four areas that we all broadly agree on as positive for community building. But I think having representative across the community of Manawanawa and the project to evaluate the applications and requests hopefully results in an accurate and beneficial distribution of the funds.
Sure. So that's something that you see would be facilitated with perhaps through the council or through some administrative body. Yeah.
Yes.
Is that something that could be formalised through the consenting process if the project were to advance?
Yes, our intent is to formalize the commitment so that it goes with the project, assuming the project moves forward.
That might be something for you planner to respond to, because I haven't seen that in any of the conditions, but that might be something that we could discuss further.
Okay, happy to do.
Thank you.
Thank you. So 7.7. There you're talking about, you've said an efficient solar farm works best on land with a slope of less than 5 degrees, which is why large flat sites are often associated. Can you give us a really quick summary of why that is?
The idea is to keep the solar panels facing the sun as directly as possible, as much of the day as possible. So the single axis tracking structure, as you probably have gathered from our materials, follows the sun over the course of the day. You have a long pivot rod on which those panels rest. And so you can imagine if you have an axle that goes over a severe curve, it makes it more difficult to roll. The technology that's coming through with tracking systems now is improving constantly. And so you can have a more undulating site relative to what you would have seen for a tracking site location a number of years ago. But it's still, in terms of deployments, in terms of construction, and then in terms of operation, the flatter site makes it easier to track the sun, easier to construct the project.
Thank you. In terms of paragraph 8.6, you talked about the community consultation that you undertook, and you've mentioned 2 dwellings of the 4 closest who provided verbal feedback raising concerns. Do you know if those owners of those properties are submitters?
Yes, they are.
Yes. Do you know which ones they are?
Yes, it's the voices and the crossings.
Thank you. Yeah, I think that's what we guessed, but there wasn't any names mentioned in your evidence, so that's very helpful. In terms of just around sort of paragraph 10, construction related aspects, and I guess a general question, so the 35-year term you're seeking, will you expect to need to replace panels over that course of that 35 years, or what's the 35 years?
The 35 years is the expected life of the panel. So there will be replacements from time to time if a panel is damaged, obviously. Yes. But the expected operational life of the facility is designed for 35 years, which is why we're requesting that full term from the start of operations rather than from the issuance of consent, in order to maximize the value of the deployed asset. And then the decommissioning would occur post that 35-year operational period.
Yes, and so would you expect to have to replace like all of the panels over that period, or do you have a sense of?
No, I mean, it's barring a a large event that would cause damage. But the failure rate of the panels now is quite low. The industry has become very precise in terms of the manufacturing capacity. So I think you could expect 1 or 2%, something less than 5%, certainly,
Okay,
replacement over the duration of the line.
thank you.
Yeah, just to follow up on that, does the asset have any value at the end of that time? Are the panels useless at that time, or can they be used somewhere else? Is there any incentive for you to take them away and use them somewhere else, or is that not feasible?
It's hard to see 35 years into the future.
I know.
And with deployment of technology that is leading edge today.
Yeah.
Certainly with other solar projects that are being decommissioned now, panels are redeployed and reconnected. The other thing that's happening, and we address this, is the recycling of the panels and what the constituent materials are in a panel. So it would be quite a few panels to find a random home for it. If, you know, if people were talking about redeploying them on a rooftop. So the most efficient way is to decommission the site, to remove all the infrastructure, to recycle the aluminum, the glass, and the trace materials. Copper, for example, can now be extracted. Panels essentially pulled apart. I won't go into the details, but there's some very interesting technology that's being deployed in recovering materials from solar panels. And that will only increase as more of these panels become available from decommissioning.
Thanks. Thank you.
I have one more question for you. 12.16. You've talked about insurance, which obviously is pretty important. I would have expected for you to have comfort that you can, you know, deliver on what you need to.
Yes.
You've talked about at the second sentence, the level of insurance of the project is required to hold will ensure that damage is repaired and the project is returned to operation in order to avoid a mass loss to project financiers. When you say required, who requires that insurance?
Two parties, the investor / owner, but then also a lender will absolutely require replacement insurance. They have a significant investment, obviously, in the project, and if it's not operational, it's not producing the revenue to repay the debt or repay the return on the investment. So both the equity investor / owner and the lender will require replacement insurance. We work with insurance companies on an ongoing basis. We have a relationship with our insurance provider, and we're very current in terms of the availability for coverage on projects like this, the catastrophic risk and replacement issues that come with it. As you can imagine, solar growing in Aotearoa, New Zealand is an interesting situation where we're a land of volcanoes and earthquakes and floods and cyclones. And so insurance companies are very much doing their homework to understand this, and they are offering coverage that we require.
So that was going to be my follow-up question: is there any issue about getting insurance for these? Have you actually, because you haven't built any before, so
We have secured quotes for insurance.
and you
for our
don't see any
site.
concern. You haven't got any concern about being able to find insurance?
No. No.
Thank you.
Yes. Thank you. In your evidence, you discuss and address some submitted concerns around accommodation
Yes.
and the influx of construction workers, and you have described how you imagine that might play out. And then in the last paragraph there, you've talked about Helios's desire to coordinate with the community alongside your lead construction contractor so that an influx of temporary workers is a benefit and not a burden.
Right.
How did you see that happening in terms of, would that somehow fit in with the construction management plan that would be conditioned if the project was to advance? Or is that more just dialogue or?
From a commercial perspective, we engage what's called an EPC contractor, engineer procurement construction contractor, to provide the full services, including the labor to build and execute on the construction plan. We have very distinct procurement provisions and policies on how they are to conduct business when they are in contract with Helios. And so local engagement, local procurement, local hiring, training is all part of that contract that we sign with the EPC contractor. We can guide how they approach it and require that as part of their obligation under the contract. But I think the actual interaction for hiring would be by the EPC contractor, and they would have a framework within which they would need to operate. In engaging with the local community, we have existing relationships, obviously, with the landowners, with council, with others, with Monofenua. All of the stakeholders have an interest in sort of meeting that test. Again, that's important that we are a benefit and not a burden to the community. And so with regard to housing, we don't want to occupy housing that precludes others, better paying visitors from occupying that, or disrupt travel and tourism here. So it is up to Helios and our contractor to find solutions that are either bringing workers to the site from a further distance, say Alex, as an example, or even for very temporary periods, seen other projects in summer construction time, which is when the high point of activity on the site will be, and that's really panel placement of temporary camps. Again, we want to do this in a way that is respectful and accommodating to the community. So I don't have specific details on how our contractor and Helios would work together on that, but that is part of the framework.
Thank you. I see in the latest proposed conditions, there was some in the construction management plan, there was a condition there or a commitment that in relation to transport of contractors to and from the site, that there might be some. So I was wondering whether there might be something that could be built in there. I'm not certain if that would be, if there's merit in that at all, but in terms of just, I guess, providing that cohesive.
Right, and that concept of having shuttles rather than having individual vehicles coming in with one person, that makes much more sense. We don't want to have traffic jams here in Ranfurly or Naseby. So happy to consider that as part of the transport plan.
Thank you. And in paragraph 10.3 of your evidence, you address some contamination risk from solar panels in response to some submitter concerns. And I'm interested.
10.3.
10.3. 10.3.1.
Oh, 10.3.1.
Yeah.
Yes.
So my question is, it's very, it's quite specific and it's quite technical. So I'm interested in, is this your knowledge that you're sharing from your experience in this industry, or are you relying on the expertise of Ms. Rubios here, who I believe prepared some assessments in the application documents?
I am not an engineer, and so this is not my technical expertise. This is a combination of the expert advice and industry experience of the Helios team.
Yes.
But the issue of what is and what is not included in a solar panel composition is important, because some of the concerns relate to components that are no longer used in the manufacture of solar panels, cadmium in particular. And so we arranged, we secured the detail on a representative panel on current industry. What is actually a component of that? And we've done a fair bit of research on how that works and what the recycling process is now. What is the risk of this breaking down? Is there any risk of leaching from chemicals or components that are part of a solar panel? And so our response is laid out here. But we can provide further evidence of that would be.
Just one.
Okay.
I was just going to ask you one question. I was just selecting a fundamental question, really. It's a very large site. I'm confident in saying it's the largest site I've ever had to visit, and I've been doing this work for about 40 years. So it's a huge site. And I just wanted to test with you why a site of that size is needed. And you do address it in your evidence at paragraph 710. And I just wanted to ask you a couple of questions on that. First of all, you said that it needs to have 300, and I'm going to say megawatt AC. I don't know what that is, but 300 megawatt AC to connect, to make it viable to connect to the Naseby substation. So that's the first consideration. And you say in here that it's your opinion, shared by other members of the Helios team and your connecting engineering advisors, that that's a minimal project size. So this site is large. It does include some highly productive land. It's got some ecological sites. And I'm just wondering what ability there is to make it smaller potentially, or is this is the site you need and it cannot be any smaller? What's your response to that?
One of the primary drivers in the economics of a prospective solar site is the connection to the national grid. So the high voltage connection at the Naseby substation, the cost of the infrastructure to deliver the electricity from the solar site to the grid, the connection, the transformers, the studies, all that goes into that, that is essentially a fixed cost for that connection at 220 kV, 220,000 volts. And you're right, it's 300 megawatts AC is a common, the AC megawatts is a common denomination that's used in the industry to say it's a 300 megawatt site. We talk about the Clyde Dam. And so, again, without going too far down into the details, this is how we in the industry measure size, productivity, capacity factors, et cetera. So that fixed cost of connecting the project doesn't change whether you have 10 megawatts or 300 megawatts. If you want to connect at 220 kV at that Naseby substation, there's a certain amount of cost that you need to spread across the project. And we look at this holistically, where you have development costs, you have construction costs, you have operation costs. This is all part of a 35-year operation plus 5+ years of development, construction. And we look at all of those costs and the return that would be required from an investor. And so there is essentially a minimum threshold of productivity that you need to have from the site to justify the cost that's involved. And again, it's not just the substation, it's all of our development, consenting, leading costs. That's all going to be the same amount, whether it's 10 megawatts or 300 megawatts. And so when we looked at this site, we knew that the connection costs would be significant. We knew that constructing a project here in Central Ottawa would have certain costs associated with it. And we identified this site. And when we look at the economic pro forma, the cash flows for this over that 40+ year period, projects that are of smaller size have a lower return and start to become economically challenging. In the current market, I know that there's a lot of discussion around wholesale energy prices and the impact on industry. from a solar perspective, we will have a contract ultimately for the offtake of this, and it will not be for the prices that are in the news media. It will be considerably lower. And most likely that will be with one of the large gin tailors. And so we have to estimate what is our revenue, what is our CapEx. I know this is getting to be long-winded.
Well, I think you've answered my question. I just wanted to test the statement here, which was, it's in your opinion, and you've fleshed that out a bit more. There's another consented solar farm nearby. Is this of a similar size to that, for instance? Because that'll be connecting to Naseby as well, won't it?
It is a smaller size and it
Smaller,
is,
yeah.
yeah, it is a different connection.
Oh, that's,
So I don't know the details of the other site or, you know, their
yeah. Okay.
costs rolled out, but yes.
I think you've answered my question, but we might have a look at I think we have a copy of the decision for that other site. We may have a look at that just out of interest, but thank you very
And
much.
yeah, and I'm happy to go back and refresh my memory on
That's fine.
how they're connecting and why their costs would be low.
Thank you very much. No more questions.
Yep.
Okay, I have one question, which is really, I'm wanting to understand at a real practical level, how the solar panels work in relation to the height of the ground and how sheep will graze and be able to shelter underneath them.
Right.
Could you talk me through, I've seen some numbers in the application that at times the solar panels will be 1.8 metres high at either end of the day. And then at other times they might be 0.5 metres off the ground at maximum angle. So, yes, so I'm wondering in terms of sheep grazing, are there any constraints at any time of the day, depending what angle the solar panels are on, for them to be able to do what they need to do?
Yes.
There's probably some sheep over
Having
here.
visited
Yeah.
active sheep graze solar projects, and there are a variety of factors that come into play. But our intent with this design is to allow sheep to have mobility pretty much all day. Now, the panels can be stowed vertically in a situation, for example, if there's a storm coming, a hailstorm, they can be stowed vertically to avoid the direct impact. There are various reasons why you would want to, but you can control how they are stowed. The other thing to remember is that it's only a small portion of the site, relatively speaking. I think the number 21% ground coverage ratio on this particular site. So sheep have avenue all the way around. There are breaks in the panel rows. There are access roads. The rows are 7+ meters apart, and so there is plenty of room for the sheep to navigate the panels.
Yes, and also to be able to, so in the application documents and some of the evidence statements, there's also that they can shelter underneath them and take refuge, I guess, and graze underneath them. So I am interested in, does the heights or the change in the angles during any given day present a constraint to sheep being able to access underneath?
No, it shouldn't. Again, imagine to the extent that the panel is at this angle.
Yeah.
The height from the lower edge during the majority of the day would not preclude sheep, but they can also walk around this side.
Yeah.
They're very clever that way.
Yeah.
Especially if it's raining.
Yeah.
So.
Yeah, sure. Thank you. And my last question, at paragraph 12, no?
Just one more on that. So have you seen other solar farms in action that have sheep grazing
Yes.
in New Zealand?
Not in New Zealand. Large scale solar is now just starting to take off here in New Zealand,
Where have you seen that?
in Australia,
Okay.
and then also in the States.
And do you know, have you talked to those operators about whether there is I mean, are you expecting there'll be a reduction in the stocking rates?
It's
And this
very
location.
specific to the particular land, how you would stock it. There is potentially some reduction, simply because you have infrastructure on site. The interesting studies that are coming out, though, is that in many cases, because A, you have shelter from rain, and B, you have shelter from heat, the wool production, if you're running merino, is actually started. There are some studies that are showing it's improved. Just overall, the impact on the grass is being studied, and what we're finding is that the shading impact is actually a benefit. And again, 80%, 70 to 80% of solar farms are not shaded by the solar panels at any point, and because the panels are moving within the course of the day, even the area directly under the panels is getting some sun.
Thank you. My last question relates to the matter of whether a bond is needed or not, and you have addressed that in your evidence. At paragraph 1214, you've mentioned there that a 450 million project with no valid land rights is of very little value. It is therefore inconceivable that a project financier would fail to step in and remedy such a breach of the project land lease where the alternative is a loss of rights for the project to occupy the site. This would destroy the value of their significant investment in the project. And so my question is, if you are coming to the end of the project's life, there could be an argument that there is little value left to continue to occupy the site. So would the value of the investment, in terms of committing to the decommissioning process without a bond, if you're about to leave the site and that the project's left, there's no remaining value in the project on this particular site, how do you see that?
That's the very important distinction here, is that under the lease agreements that Helios signs, we have an obligation. We have to fund a decommissioning reserve, either through an investment grade guarantee or through a registered bank, that at the start, in year 6, so you have 5 years where the project is brand new, it is operating as expected, it is worth the 450 million that has just been invested. In other words, there hasn't been depreciation or degradation. And so those panels, that system, all have a lot of value, much more value than it would cost to decommission if in some bizarre set of circumstances that needed to happen. The commitment we make to the landowners is starting in year 6, we will fund this reserve so that what you're describing doesn't happen. We will have a qualified expert assess the cost of the decommissioning effort. And this can be a very costly effort. We escalate those costs over time. We revisit them periodically to make sure that those estimates are still accurate. And the cost, the decommissioning cost, is to remove all the materials from the site and restore it to the condition in which we took it. And so this is exactly what you've described is exactly why we make this commitment to the landowners. Honestly, in 35 years, I don't know that I will be here. The landowners and their kids are going to want to be sure that someone is there with the financial wherewithal to restore the site as promised. And so this decommissioning security that is in the lease contracts, that's what protects them. And so my point earlier was, for the council to require a bond, it is redundant. This commercial arrangement is what the landowners will look to, and they are the ones with the vested interest in this site and having it restored to its prior condition. And so and come around to your question, if in year 35, we say no, the project's, it's no longer operating, it's not valuable, there is recourse to this decommissioning security so that the landowners get their site back. I just want to be clear on that. That's why we have pushed back on that condition, is that we feel it's redundant. We feel we've addressed it in actually a better, more direct route.
Thank you. And so earlier, I think you mentioned that you thought it would be a duplication. And I think you specified, I can't quite see the paragraph at the moment, that it would be a doubling in costs if there was to be a bond imposed as well. Where does the doubling of cost come from? How did you determine that?
Well, it's two separate bonds, correct? So there is a cost for providing a bond. It's essentially between 1% to 2% of the face value of the bond annually as a cost to provide that security. So if the council were to require us to post say, $30 million decommissioning fund, then the bond on that would be 1% of that 30 million. In the best case, probably more like 2% of that 30 million every year for the 35 years. So that's the cost that we would have to pay for the bond to the council. We will have to pay that same cost in some fashion, either through guarantee or with a bond to the bank in our agreement with the landowner. So we'll have that cost twice. But the issue is there won't be twice the cost to decommission the project. And so that's why I say it's redundant. It's double.
Thank you.
Just for staff, obviously this is of interest to us, and what I'd be interested in hearing from you about is how the bond would work in practice, and whether Mr. Strickland is correct with that you would actually expect a payment per year to keep the bond go, or is it a guarantee, or how would it actually work in practice? Thank you. All good. Great. Thank you very much. Really appreciate all your thoughts and answers to our questions. We will take a short break. We'll reconvene at 11:40, and we'll hear from Ms. Sebright. Is that right?
Thank you.
Thank you. We'll get the heaters back on. I realise it's getting very chilly in here. Ms. Sebright.
Now, just before I hand over to Ms. Bright, just following up on Commissioner Ray's question in relation to the National Policy Statement of Indigenous Biodiversity, because it'll be relevant for the next couple of witnesses. So clause 1.33 of that National Policy Statement says nothing in this National Policy Statement applies to development, operation, maintenance, or upgrade of renewable electricity generation. So there is a specific carve out for renewable electricity in terms of the MPSIB. Having said that, in terms of the effects management hierarchy and that approach, that is certainly something that has been applied in any event. And so both Ms. Sebright and Dr. Morris are very happy to address those aspects and just to talk through that effects management hierarchy that has been applied in any event. But from a strict legal perspective, the reason the MPSIB isn't relevant is 133.
Thanks for that. Good.
But section 6, obviously, of the Act still is.
And so we have all of these effects still being applied. It's just the MPS itself is not a relevant consideration for you.
My evidence addresses the potential effects of rejection AV corner. The proposed project site is dominated by great.
Can I just stop you? I'm just assuming everyone's going to read their executive summary. Is that right?
Yes.
That's what you're doing? Sorry. Perfect. Yes.
So the proposed project site is dominated by grazed pasture, short rotation cropland. Other habitats on site include exotic shelterground, woodlands, obstructed stock ponds, and small areas of Indigenous shrubland. These habitats provide foraging, roosting, and or nesting opportunities for Indigenous avifauna, including 15 not threatened species, 5 at-risk species, and 1 threatened species. The ecological value of these species ranges from low, not threatened species, to very high, threatened species. In the ecological impact assessment that I co-authored for the project, I concluded that without effects management, all potential effects on avifauna would be either very low or very low to low. Low effects were assessed as very low for nesting birds. To further manage effects, I recommended that if works commenced during the main bird breeding season, a pre-construction nesting bird survey was conducted and exclusion zones established around active nests, and which works cannot occur until nesting activities are complete. Although effects were assessed as very low for bird strike, given our understanding that the project was granted consent, construction would not commence for a number of years. I also recommended conducting a literature review report summarising the current state of knowledge on bird collisions with ground-mounted photovoltaic solar arrays at least 6 months prior to the commissioning of the solar plant. The outcome of this literature review would inform the need for bird strike monitoring at the site. I have considered and responded to Central Otago District Council Section 42A report, including CODC's technical peer review report of the ECIA that was prepared by Mr. Andrew Wells and colleagues from Wildlands Consultants. I've also considered and responded to submissions that relate to avifauna. The key avifauna related issues that have arisen from the reports and the submissions include the following: that the ECIA has not considered potential effects of the project on Australasian bittern, a threatened nationally critical species, that the ECIA may have underestimated the potential risk of bird collision with the solar arrays for migratory shorebirds, that the period in which pre-works nesting bird surveys are conducted should be 1st of September to 31 March, rather than 1st of September to 29 February, as recommended in the ECIA, that consent conditions should specifically address monitoring and mitigation of adverse effects from bird strike, that any updated consent conditions based on discussions had with DOC are provided to CODC prior to the hearing. They may warrant reconsideration of the conclusion of section 62 of the section 42A report. That management plans are certified by CODC, must be complied with, and must include objectives, intervention thresholds, monitoring provisions, and performance standards. I've considered all matters and my key responses are as follows. Based on data provided by DOC following preparation of the ECIA and my evidence, I have assessed potential effects of the project on Australasian bittern and consider that all effects will be low. Based on the same DOC data and my evidence, I have reassessed the collision risk for migratory shorebirds and have conservatively increased the overall level of effect from very low to low. I consider that the main bird breeding season for the species that may nest on site has been appropriately stated in the ECIA. However, taking a conservative approach, I agree with extending this to 31 March as recommended in the section 42A report. This is reflected in the updated consent conditions attached to the evidence on this heading. I have been involved in a meeting with representatives from DOC regarding their submission and have subsequently been involved in updating the proposed draft consent conditions for avifauna. Helios and DOC have reached agreement on the proposed conditions of consent for avifauna. The agreed conditions are provided in section 9 of my evidence and are attached to the evidence in this heading. The proposed conditions now provide certainty that 3 years of avifauna collision monitoring will occur on site, as per methods to be outlined in the bird monitoring plan, a BMP, that will be prepared for the project. Mortality thresholds have been developed, which have triggered require the development and implementation of the bird collision management plan, a BCMP. The BMP and if required, BCMP will be prepared in consultation with relevant stakeholders and will require certification by CODC prior to implementation. Accordingly, I consider that the issues raised have been appropriately addressed and contribute to a robust assessment of the project as it relates to potential effects in avifauna.
Thank you, Ms. Wright. I do have some questions for you, and I'll just take you through the substance of your evidence statement. So my first question is at paragraph 6.3. So here you're talking about permanent habit loss and modification. And so when you say permanent, are you meaning within the lifespan of project?
Yes, that's correct.
Right, okay, so once the project is decommissioned, it would then
Be reinstated.
reinstated, right, so, okay, so that's got quite a specific, it's not permanent forever, but
For a long
permanent.
time, but not permanent.
I see, okay, thank you for clarifying that for me. Paragraph 8.9. So here you are discussing, I'm just it's taking me some time to arrive at that paragraph for some reason. Just give me a second, thank you. So here you're explaining in your view that the application of a 10-metre setback to the small wetlands would minimise the lake effect from the Wildlands peer review, and you don't consider that that increased setback is required. Could you explain that for me now in terms of the key difference between your view and the recommended 10 metres?
Yeah, I think that the 5 metre setback that's currently proposed, in my mind, that already sufficiently reduces the potential of the lake effect appearing on the site, together with other mitigating factors that we have. So, for example, the site is visually interrupted by the way of existing wetlands being retained on site. Some gutterabouts being retained, there would be an additional 5 kilometres just about filched. So these are all things that sort of reduce the lake effect. And I think the 5 metres that also, this 5 metre setback also sufficiently reduces the effects that if we increase it, I don't think it would materially reduce that effect any further. So in my mind, yeah, I don't see that if you increase it, there would be a great reduction in potential collision risk for birds.
Thank you. And the difference between 10 and 5, is that kind of a known piece of research you've drawn on, or is that using your experience in this discipline to understand what difference that might make?
It's just based on my opinion. So the setbacks have been set by Dr. Morris. And yeah, I've just used it primarily, I've just looked at it and said, hey, this will break up the site sufficiently to reduce this potential effect. And yeah, I don't think that if we increase it any more, that would have a material reduction in collision risk specifically, or the site looking like a lake.
Okay,
Yeah.
thank you. So I've got a question around the proposed condition around the bird monitoring plan. So the mortality thresholds, so everything in table 1, is that all informed by the national threat classification, or are those thresholds developed separately to those guidelines?
Yeah, they've been developed separately. So we developed them just based on some expert opinion primarily, and then that's been run plus doc as well. But I've worked on quite a few wind farm projects, and we've sort of used one of the wind farm guidelines for their thresholds to sort of guide what would be appropriate in this case.
I wondered about the wind farm.
It's not directly comparable, but it does provide a guide. And yeah, we have run this by doc, and they're comfortable with what's being proposed here, and it is relatively conservative. And I'm talking about one tax of the threatened species, so we're trying to be sensitive.
So you're confident that those they are best practice, if you like, mortality thresholds that are grounded in.
Yeah, no, they're not standard. It's not standard.
Not standard?
Have that.
No.
But yeah, I think it is definitely based on it's expert opinion.
Yes.
Other experience that we have in other sort of similar projects.
Yeah. And did those thresholds have much discussion? Was it a discussion point with doc, or were they generally accepting of those?
They're actually generally very accepting. The one thing they asked to change the wording was around, for example, let's see, some of the threatened nationally vulnerable. So 3 carcasses detected cumulatively in any consecutive 12-month period. That was a discussion point. We'd previously said it would be a 1 year of monitoring, but we've gone with that rollover effect, which in my mind makes more sense. So, but they were happy with the numbers that we have proposed. There was no discussion on that.
My other question related to your recommendations for the literature review. Findings. So clearly there's an absence of data or research at the moment around this sort of risk, which you've identified in your evidence. And so hence the proposal to put forward the literature review and any consent that might be granted. In terms of the project timeline and the commencement of the project, you've said that its construction would not commence for a number of years. So are you thinking, what's a number of years? Is it 3, 5?
Yeah, that's my understanding, and that's the order.
Yeah. And so within that timeframe, is it likely that there will be sufficient literature that would provide that meaningful guidance
I mean,
in your experience?
that is the hope. So it won't just be based on New Zealand data. We will also look at what other international information is out there. But in New Zealand, there's a handful of consented solar farms currently now. There's quite a few more in the pipelines as some being constructed.
Yes.
To my knowledge, none of those solar farms have conducted any collision risk monitoring to date. But in the intervening year, I would assume there will be some monitoring. But if we don't have that information, we'll just base it still on international literature and what seems to be best practice.
Right.
To enable development of the monitoring plan. Yeah.
That was going to be my next question. If you were aware of what monitoring programs were in existence to give you certainty that there would be enough data for you to draw on. But I think you've addressed that.
Yeah, none to my knowledge. I don't believe there is any monitoring being conducted to date, but I know that there are a number of projects in the consent process currently, and monitoring is definitely being something that's being highlighted and being built into a lot of the projects now. So I expect there will be some data in time. Yeah.
And is this type of condition that you're recommending in the absence of information, that this is you've said that this is a conservative approach? Have you seen this type of condition being put forward, obviously in the wind context, for example? Is this something that you're comfortable with providing that kind of to inform any management response?
Yeah, I am very comfortable with it. I mean, I think even if we didn't have that condition, this is something that we do anyway to try and determine what we need to be doing to monitor the management. We need to do a literature review anyway. So this is just providing steps for what that will entail.
Yeah.
So we can realise best practice. And as we said, yes, also drawing on wind farm projects and whatever else we can for a robust design, which is basically trying to gather the best information we have to then be able to conduct the best sort of monitoring that we can to get fatalities.
Sure, thank you. And what circumstance would require a kind of full precautionary approach in terms of a threatened species or in the absence of knowledge or data? In your experience, where's that line drawn
With regards to,
I guess, that where you might reach an opinion that something should not go forward because of the risk to a certain species? Is there?
well, I suppose we've got that table that
Yes.
we developed that will be written into the conditions. So if we trigger any of those mortality thresholds, that would then require some sort of mitigation to be implemented to respond to that event. So there's that built in. So then yes, it requires some mitigation to be implemented, and we follow up by the monitoring as well to make sure that is being successful, and then that fatalities do not continue.
Okay, thank you. That's my questions for you.
I only have a question about the condition, but it's probably more for the planning witness. It's probably not to trouble you. It's the way the condition's constructed. So I'll park that, but it's to do with condition 24. I'll say it very quickly. It's condition 24, the advice note, whether that should be elevated to an actual condition, but that's not for this witness. So thank you. No other questions.
I don't have any, so thank you very much.
You. Next witness will be Dr. Morris.
Good commissioners. My name is Jazz Morris. My experience and qualifications are set out in my evidence. My evidence describes the existing terrestrial ecology environment and assesses relevant effects of the proposed Helios photovoltaic solar farm at 48 Ranfurly Naseby Road, Naseby, the site. My evidence focuses on terrestrial vegetation, including wetlands, and terrestrial fauna, excluding birds, which have just
Yeah, we've muted them now.
my evidence.
Apologies,
That's
carry
fine,
on.
that's absolutely fine.
No.
My evidence excludes birds, which obviously you've just heard from my colleague, Mr. Wright on that. I was an author of the ecological impact assessment report for the project, and I have visited the site to undertake ecological surveys. The site is predominantly exotic pasture or short rotation cropland raised by sheep and beef cattle. Indigenous plant species comprise relic shrubs scattered in places along fence lines, and limited other species are found in wetlands. The pasture is of negligible ecological value, but indigenous shrubs are of greater value. Two main wetlands on the site, which I've called the central and southwest wetlands, just in relation to where they are in the site. They are impacted by existing land use, but they support indigenous species and are of moderate ecological value. The site also includes 44 very small features that are technically wetland, but of negligible ecological value due to a general lack of indigenous species and their context among farming land use. The project has been designed to avoid all wetlands, with wetland-specific setbacks of between 5 and 10 metres, and the proposed use of horizontal directional drilling in sensitive areas when installing electrical cabling to prevent surface disturbance. A small number of indigenous shrubs within the development footprint will be cleared, but this impact will be remedied through planting at least double the number of shrubs in other areas, including along site boundaries and at the margins of the two larger wetlands. I conclude that the project will avoid adverse effects on wetlands and will appropriately manage impacts to indigenous shrubs. The proposed fencing and enhancement of the two larger wetlands are expected to result in a net ecological gain for these features. There are only two main differences between my conclusions and the conclusions of the Section 42A officer's report and an accompanying technical peer review. These relate to wetland setback distances and the need for further plant surveys. I do not consider these differences are critical or unable to be resolved. I have had input into the applicant's proposed conditions of consent, the updated version attached to Ms. Garnetti's evidence, and I consider the ecological effects of the project can be appropriately managed by implementation of the requirements of those conditions.
Thank you, Mr. Morris. I wondered whether you could, the vegetation map that's attached to your evidence, does that contain in the graphic supplement here at a large scale, or?
Leave it in.
I'm just wondering.
I have an A3 version if you like.
Yes, it might just be handy, I think, because we've had the A4 and it's the colour coding can be difficult to get around.
Sure.
If you wouldn't mind, it would assist us if you could take us through the key ecological features that you have just addressed us on, so that we can really get an idea around those, and also potentially inform if we go onto site, where we might visit, where we might.
Karen, are you able to get that plan up? So we're
Yeah,
in
which plane's that?
Dr. Morris's evidence.
That will be attachment 1 to my evidence, I think.
Yes.
Find the page of Dr. Morris's evidence.
And look, we can certainly provide that as a standalone PDF if that would help to get into it in higher resolution.
That would be great. I just think for the people in the room, it'd be good just if we could bring that up.
Yes.
See how we go.
Just give me 1 second, so my internet's a little slow. That's a big folder.
That's okay.
That's okay. Send it to me. Just the PDF, the vegetation map at the bottom.
Yeah, it's just
Yeah.
the very last page of the evidence.
I'll just send it to him.
Sorry, put on the spot.
That's okay. I'll just do 1 second.
Here we go.
Coming through now.
Awesome. Yeah, we might need to. They're going to be tricky.
No, that's right. So just open it and then just go share that screen. All right, now I can.
There's something.
Oh.
All right, I think we'll carry on. That just for the team, some people have printed things out, I see. Excellent. That's the last page of Dr. Morris's evidence, and there are iPads and things if you did want to have a look as we go. And perhaps at the end, we'll just leave that PDF just sitting on the edge of the table if submitters would like to come and have a look. Thanks.
Thank you. Thank you. If you could just talk through the key components and the proposals as recommended in terms of the removal of some of those shrubs and the doubling of where they should go. Yeah. And also the wetland location.
Sure. Yeah, I appreciate the comment around scale. Ordinarily, as far as an ecological impact assessment for a project that perhaps had more complexity, one would prepare a vegetation map that would sort of colour code the different vegetation types and so on. You might have some forest, you might have some pasture and so on. I suppose that the scale and lack of colour in this map is indicative of the fact that largely we have the same habitat type, I suppose, from a terrestrial vegetation perspective, which is either exotic pasture or some exotic shrubland, which from an ecological perspective are similar in terms of their intrinsic value. What this map shows is in the grey dots, the locations of, the dots in general, the locations of particular plants, primarily a number of locations of Matagauri and other indigenous shrubs, where they form a kind of a strip along a fence rather than just one or two. We have the two larger wetlands stand out a lot more. So that's one in the centre of the site. The water that drives that wetland appears to spring up, emerge from the ground in a number of kind of little fingers, and then that coalesces downstream, but then that water then infiltrates again to ground. So it's kind of starts as a bit of a hand shape almost, and then turns into a bit more of a channelized thing right in the centre of the site. On the southwest, you see another wetland associated with a water race, and the margins of that race. There's also a number of small features outlined either in a kind of teal colour or in a light green that indicate what I'm calling the small wetlands. And they're all, when I say small, the average was a 0.013 hectares, so a kind of a quarter acre. What those are largely is depressions in the landform where direct rainfall accumulates, and you can see that the site is quite kind of pockmarked in the southwest there. My suspicion, having looked at the imagery that was available when we did the mapping, as well as more recent imagery, is that this has been taken at the time of rain. Those dark areas is where water is ponded. But when we've visited these areas twice, both outside and within the growing season, we've not found wetland vegetation there or wetland hydrology, those sorts of factors. So all of those sites have been visited, but it's only the ones with the outline that were found to be wetlands. You'll also see in the northeast, taking you to the other corner, and along the Ranfurly Back Road boundary areas of Indigenous shrubland. And I guess I differentiate that from the isolated shrubs scattered along the fences, and that, you know, they might be in association with taller rank grass or even some tussocks. That they're more of a cohesive shrubland rather than individual things. And I suppose what's not shown on this mapping is that there is another wetland stream area at the very northeast corner. Now, I suppose that's not been shown on the map because it's well outside what was ever considered as part of the build area of the solar farm. It sits down on a lower terrace. And so while that shrubland there is showing the wetland itself in that northeast corner is sort of well outside of this vegetation build area.
Thank you. That's very helpful to see that while you're talking. So the Indigenous shrubs that will be cleared, are they then on that map, that's the at-risk plant locations with the dot symbology?
No, not quite. So the green, orange and yellow dots
Yes.
are all in areas that are either part of wetland setbacks or site boundary setback.
Yeah.
So we're looking primarily at the grey dot, which is Matagauri, which is actually no longer at risk. That the correct classification of that species has been reconsidered since this map was prepared. Where you've got the grey strips, you have Matagauri in association with other Indigenous shrubs, desert broom, scrub portway, and desert broom is an at-risk species. So it was, I guess, bundled in the grey lines rather than as a dot.
Thank you. Mr. Vincent, in his section 42A report, at paragraph 58, he speaks of the proposed mitigation or remediation. He labels it as an offset and compensation. Now he hasn't addressed that in his statutory assessment, but I found that interesting, and I haven't seen those terms used in your evidence. How would you, can you talk me through the effects hierarchy and how you see it in terms of section 104 and the difference between that and an offset, or is what you're proposing an offset under the RMA?
Can I clarify, are you just in relation to shrubs specifically?
Yes, in relation to the shrubs where you've identified that there's high value, they're going to be cleared.
Yes.
They're ecologically significant and there'll be moderate effects. And the effects cannot be avoided, so they're going to be moved.
Sure.
So I'm interested to hear how that fits within the broader effects assessment approach under the RMA and how that aligns with Mr. Vincent's terminology in his AEE.
Yep.
Okay.
I don't consider in my professional experience that we're talking about offset or compensation here. I think to me this falls squarely in the camp of remediation. Because we are very directly remedying the loss of shrubs within the site by replanting them at the site. To me, an offset approach would be to replant those shrubs at a different location, and a compensation might be to plant different species or to do something for lizards or something like that. So in my mind, I see this as the remedy.
Okay, thank you. That's very helpful to understand. And is it always the case that it has to be on the same, remediation is on the same site?
That's certainly how I've always understood it to be applied.
Yes.
I think that there's probably some case law tied up in that I'll leave to counsel. But that's certainly the way in which I would approach.
Yes.
It's not necessarily that they would be put back in exactly the same spot as they previously were, but I'm not sure that that's what's contemplated by those terms in my ordinary practice within the same site and within the same ecologically functioning area would be the key
Yes,
matters to consider.
yes. Good point. Thank you for that. If I can take you to paragraph 617.
Yes.
Can you talk me through what you mean there in terms of the unbuilt areas of the solar farm and the resultant impact or otherwise?
And that paragraph by unbuilt, I'm referring to the 5 metre buffer around any given small wetland, or the 10 metre buffer around the 2 larger wetlands. So the smaller wetlands in this case are not proposed to be fenced, so they will continue to be accessible to sheep. And essentially, from an ecological perspective, those small wetlands will experience status quo, or potentially even some slight improvement, because I have observed beef cattle at the site. I understand it's largely sheep, but cattle, as I understand it, are no longer will be no longer in the picture as part of the solar farm proposal. Would be sheep only. The important point there is that cattle will much more readily stray into a wetland and hug a wetland and so on than sheep will.
Thank you. Paragraph 8.6. Here you're responding to one of the outstanding matters between yourself and Mr. Vincent around the spring annual plants and the seasonality of surveys. So I understand that in your opinion, the additional survey is not required because there's no ecological advantage to it. Is that correct?
Well, I think the species in question, the spring annual species, have quite particular habitat requirements that are quite unusual. You know, they're reliant on things like thin soils or saline soils, or being in a kind of a sweet spot at the edge of a wetland for a couple of these plants. Now, that sweet spot at the edge of the wetland is exactly where my colleague, Ms. Schlowitz, was undertaking her wetland delineation work when she carried out the wetland specific survey subsequent to my visit with her, where we did the initial ecological work. So what I'm saying is we've looked at those areas already with a view to establishing exactly which plant species are in them. We haven't picked up on those species. There's nowhere else on the site that I would expect to even plausibly provide suitable habitat. And so even if they were there but were missed, it's most likely that they would be at the immediate edge of or within what we've mapped as wetlands, and they'll certainly be captured within that 5 or 10 metre buffer. So if you were to find them, you wouldn't do anything differently as far as you would still apply a setback, still would build there. The habitat requirements and things for those species would remain unchanged, would remain status quo.
Okay, thank you. So, can I just check if is Mr. Espy and Mr. Wells, are they listening online at the moment?
Mr. Espy's online, Mr. Wells is in the room.
Oh, he's in the room. Great, excellent, fantastic. Thank you. Yeah. So in terms, I can appreciate what you've shared with us just then in terms of your understanding of that. In terms of any consent condition, and this is probably a question for your planner, so it might be unfairly asked of you, but in terms of if there was to be a condition required, it wouldn't represent a disadvantage in any way. It would be a more conservative approach. That what, in your view, or?
I mean, certainly I don't expect it would result in obtaining any information that would lead you to do anything differently.
Sure, yeah.
Were you to find those species present, we would continue to have the wetland setbacks in place. And actually for those species, they are most likely, in my opinion, to be on the small wetlands. Just going to take you for a bit of a train of thought here. The kind of the hypothetical. Those species are typically reliant on disturbance or stress that suppresses exotic grass. They're poorly competing species against exotic grass. They'll simply be smothered out. I don't expect them to be present in the central and southwest wetland where the fencing and enhancement and so on would occur. Because, for example, the Myosotis or the mousetail plant are quite often on edges of tarns and little depressions and things. And so in this case, it's the small wetlands that would actually remain accessible to sheep grazing. And I actually think that would be important to maintain to keep the grass down. So I really wouldn't expect any change in terms of what you would do. As far as disadvantage, well, no, but I suppose there's a cost to the applicant or what have you. But I don't see any other disadvantage or.
Thank you. And in terms of the setback matter, so for the smaller wetlands, your evidence states that there's no ecological justification for having the 10 metre or 5 metre setback for the smaller. You're suggesting 10, is that correct? The other way around.
The other way around. I mean, look, I suppose this is an area where I have a lot of experience in terms of wetland delineation and identification and in guiding applicants around project shaping and how their proposals can fit within landscapes where there are wetlands. There's a vast range of setback distances imposed by the different planning instruments, which I'll leave squarely in Eddie's camp. And I think in recent years, we've picked the 10 metre one because that's come through the NES freshwater as being a very clear non-complying activity trigger, leaving that planning matter out to the side. I've approached this application and all applications from a first do no harm principle, in which I consider the specific ecological values of the wetlands, their hydrological functioning, and that's a key matter in terms of these small ones that really have no particular catchment or wider context. They're often rainfall driven directly. So I've got all of that in mind when I think to myself, if you have a solar panel 5 metres away, 10 metres away, 20 metres away, what would actually change for the intrinsic values, for the habitat functioning, for the nutrient cycling, all the things that are going to be happening within that small wetland to varying degrees. Those are the things that I have in mind when trying to determine an appropriate distance. And for the two larger wetlands, I arrived at a larger distance, which was the 10 metres. And that took into account not only the greater value, it also considered the fact that you have an actual water body, the water race for the southwest wetland. So a greater setback is more prudent there, I suppose, as far as the values of that flowing water body. And then for the central wetland, because it's got that kind of fingery shape that I described, if you just strictly applied a 5 metre setback or whatever, it's going to get extremely convoluted. A 10 metre setback just makes that overall much better buffered, more cohesive, and allows opportunity for the planting and remediation work, and enhancement work. It's not remediation because it's not in respect of adverse effects, all that enhancement work. It just gives opportunity for that to occur, which I don't see as necessary or required for the smaller features.
Yes. Okay, I'll thank you for that. That's been very helpful. Thank you. Yeah.
Well,
I don't have anything, so thank you very much.
The next witness is Ms. Manway in relation to landscape and visuals.
Karen, is there a way to bring up It would be really great if we could bring up some of the graphic supplement things as well.
Yeah. We'll have to see. So, sorry, it's only in here. Graphic supplement. That was the first one I seen. Which one? On the list. Oh. Which one, yeah, just right. So this is the first one you spoke to me about this morning? Yep, yep, it's the one I just said. So, yep. The one with like the.
Well, have you got the whole supplement or? Have you...
Yep.
And then we can just.
It might just take me a moment to share it because it's I can't send it. I'll just have to send it as a link. It's a big document.
Oh, okay. We might pause for a moment.
No, I need to send it now because I just sent me one piece of it. Whole thing. That I just have to wait for it.
While they're getting set, what I would like is for you to take us through that graphic supplement, and in particular the landscape plan that you've developed, and just really take us through in some detail in terms of planting proposed and those things.
Right.
That's okay.
After I've read them.
Yeah, if you read that first, and then we'll just go through that.
It'll just be faster for you because I'm going to download it and then try and share it to us. It's just go onto the web.
Yeah. It's just easier to take it through.
Yeah.
It is our drawing.
Yep.
It's RFI response updated appendix 4. And this one? No, under document amendments of addition. It's on the amendment.
Just there. Yeah.
There should be a no.
No graphics up in here.
It's called RFI. Response updated appendix 4. Just control with RFI.
Yeah. Do you think you can help?
Appendix 4. Yep.
Oh, here we go. It's certainly there.
I'll be fine.
There we go.
That's the one you're after, isn't it?
It might not send into the, it's at the bottom,
Right at the bottom of it.
Yeah.
Yeah. That's it. Just keep going up.
It's several pages.
Keep going up.
Yeah, keep going, keep going, keep going. To the top of the A3s. Yep, keep going.
It's easy when you can do that.
Yeah. Here we go. Stop. Stop there. Perfect. Right. Thanks, Olivia. Thank you. Thanks for your patience. Manaway.
Just show that up a minute so you can see it present on the screen. We've got kids in the way.
No, the screen doesn't go. That's just how the screen works. Sorry.
You're welcome to stand up, move around if you need to. Yeah.
Don't worry about it.
This evidence is given in respect of the resource consent application by Helios for the proposed new solar farm at 48 Ranford Naseby Road, Naseby, the site. My evidence addresses the potential effects on natural character, landscape, and visual effects of the project. In relation to natural character, the proposed planting, revegetation, and fencing for wetlands will lead to an overall enhancement of natural character at the site over time. In relation to effects on landscape character and values, the proposed project is located within the Maniatoba Plain, a broad rural basin landscape characterised by expansive pasture, exotic forestry, and sparse residential development. The site itself is not within or adjacent to any outstanding natural landscapes or significant amenity landscapes as defined. While the project introduces a new land use, it can be successfully integrated into the existing rural landscape with the proposed mitigation. Visual effects are assessed from both public and private viewpoints. And I'll just also make the note here that the visual catchment is relatively contained to the immediate context of the site, out to approximately 1 kilometre. And within the site itself, there's a folded landform and existing shelf belts that break up and restrict views to the most effective public views are from nearby low-volume roads, particularly Ranfurly Maidstone Road, which borders the site to the west, and Ranfurly Back Road to the east, and will be moderate following construction, reducing to between low to moderate as planting establishes. Private views from nearby dwellings, notably dwellings 2 and 4, and they're labelled in the graphics up on the screen.
We'll come to that. Yes, I've got some questions on that. Thank you.
Are also addressed. Visual effects will be greatest during construction. Effects from dwellings 2 and 4 will reduce to low to moderate into operation and will reduce further to low following planting establishment.
Can I ask a question on that? So visual effects will be greatest during construction. What for what do you mean? Is that because the mitigation planting won't have grown then, or do you mean the construction activities themselves will have visual effect?
Both. So the activity on site, the moving of machinery, the earthworks and so on, will have visual effects that will draw the eye more than when that's not happening on site. Has the potential to raise the visual confidence of what's going on. But also the mitigation planting is being implemented during that stage. So it's not until the construction phase is complete that all planting will be in, and some of that planting will have time to embed for several seasons. The proposed mitigation measures include extensive planting, setbacks from sensitive features such as wetlands and roads, and a landscape planting and maintenance plan. I refer to as the LPMP. Measures are considered appropriate and effective in managing landscape and visual effects and are addressed in the conditions of consent. Public submissions raised concerns about landscape and visual matters such as visibility, scale, and the effectiveness of mitigation. I consider that while the project introduces a new land use, it can be successfully integrated into the existing rural landscape with the appropriate mitigation. The reversibility of the development after its 35-year operational lifespan is also noted as a factor in considering landscape effects. Peer reviews by Mr. SB in the Section 42A report with influence and generally support the findings of the assessment. Both note that effects will lessen over time and that mitigation measures are appropriate. There is one issue with a level of uncertainty indicated regarding plant growth rates due to the challenging climate in the project. I have endeavoured to address this matter by arranging the development of the LPMP, as I referred to earlier, and that included a peer review by a company called Habitat Restorations. Now they're an Otago-based contracting company, and they're experienced in implementing large-scale vegetation projects, including so they have practical experience of the local climate that item tag, so I've drawn on their expertise.
So does the information included and in the conditions reflect their advice?
I also understand the reasonableness of the growth rates provided in the offering within 25.
Right, thank you. So yeah, if you could take us through, how would you be comfortable just standing up and talking at the screen? Is that okay? It'll also help, I think, people in the room to hear you because you've got quite a soft voice, and I think they're struggling a little bit, and we can hear you fine.
Yeah.
But I suspect they may not be able to. So
Maybe I'll just take this.
sorry to put you on the spot. So yeah, if you just take us through slide by slide and just briefly explain what you're showing there and what your findings are, that would be very helpful.
Just carry on. Okay, figure 1, the landscape context plan. So this is intended to provide the wider setting, if you like, of the basin landscape, and in particular to show the landscape overlays. The yellow and the pinky colour are the outstanding landscapes that are identified in the district plan. So that shows the relationship of the site to those overlays.
Thank you.
And also shows the site in relation to Langford and Naseby, of course, and the location we've identified there of the Naseby substation, which is the red dot, and the Video Labs space radar, and the approved Solar Bay solar farm, which is just to the northwest of the site.
Well, thank you. Oh, you might want to skip through that one.
Yeah.
Yeah.
So yeah,
Yep.
This is the dwelling location.
Yes.
So the dwellings that I referred to in my executive summary were 2 and 4. Perhaps if I go back a step, I think I also talked about the viewing catchment, and that the site is relatively visually contained out to about 1 kilometre. Now, 1 kilometre, just to give you an idea, is about the distance between that edge of the site and state highway there. So that the closest dwellings within that were dwellings 1 to 5, and dwelling 1 we excluded from the assessment because that's associated with one of the dwellings. So dwelling 2 to the north, the closest dwelling 3. Oh, yes, that was this one here. Dwelling 4 to the southeast, and dwelling 5 on the corner of 5 Pass and the highway.
Yeah. Thank you. Do you happen to know, and some of your team might be able to help us here. So dwelling 1 is obviously the landowner. Dwelling 2, is that a submitter? Come on up.
Dwelling 2 is Mr. Dallin, who submitted his support for the project.
Do you have does anyone have the submission number for that?
While she's finding that it's carry on, that dwelling 3 did not submit from the project, and we had engagement with them. Number 4 is the Crossings who have submitted. Number 5 are the Voices.
Yes. Thank you. So
Mr. Dallin. No, Philip Dallin, 131. Oh, yeah.
131. Dwelling 2. Thank you. That's very helpful. Thank you.
Should we go next?
Yeah. We'll probably move through this reasonably quickly.
Yeah.
Yeah.
So that's just the viewpoint location plan, so
Mm.
that may be relevant if you want to check the locations of any of the photographs that are later on. This is the original landscape mitigation plan, which was subsequently slightly updated, so there will be a new version in one of the amendment,
So whereabouts is that?
the amendment to later.
It might be the Splintons there, is it? If they modified it.
It's in the section 92 response.
That one. That's the later.
2023.
That's the same one for those, the means of application.
Yeah. No, that's kind of RFI. So the one we've got is 24 November 23. Is
This
that what?
one's dated 2024.
Ah.
Just double checking this.
Okay.
Right, yes. Getting circled.
Okay, we might have to.
It's very similar.
Do you want to, just for the purposes of
Um,
time,
We'll come back to
Can
you
you-
just with the location of that.
that would be great. Yeah, because certainly it's not the one we've had printed.
That's the new application. Are we doing that in the application? But I'm a member of solar farms.
Oh,
Yeah.
Yeah, that didn't.
That's the LPMP, but,
We'll come back to you.
Okay.
There are,
What,
There are
for now,
tweaks, so,
yeah, if you take us through the general plan and the
Yes,
general
I can
tweaks, and if you can
probably point out
provide us with that,
yeah.
yeah, that sounds great.
Okay, so part of the intention of the mitigation response to this project was not, in the first instance, to simply hide it behind. I think we wanted more than that for the project. And the wetlands on the site, which was a pretty key part of the character of it, provided an opportunity to do that. So enhancing those wetlands, while it's also come up in Mr. Morris's evidence, is very much a key part of our landscape and natural character mitigation as well. So that's this area, the central area here. The southwest wetland that Mr. Morris has talked about is down this part of the site, and we're proposing some native wetland planting in that area as well. So essentially, we've tried to build on the existing character and reinforce what's already there and enhance it. So currently along Ranfurly Naseby Road, you'll have noticed on your site visit, there's an existing well-established shelter belt for approximately half the length of the road, and that's shown here. It does have some gaps in it and some other species that are semi-deciduous, for example. So we will propose to infill those gaps and to continue the character of that existing shelter belt, and also because that northern open area is very close to the road, and we're proposing to continue that exotic shelter belt planting to the north of the site, as the exotic shelter belt planting is likely to be grow more quickly than some of them.
So the existing shelter belt will be continued along right to the end of the site. Almost.
To the base of the ride,
Yeah.
so the site goes a bit further up than that.
Mm.
That's one of the little tweaks that we made. We
Okay.
currently showed exotic planting also happening on the hillside. because there is actually some that's already there further over to the east. But in order to sort of make the most of the wetland and waterway that's just in that, at the base of the hillside there, our preference would be to actually make that native planting area as well. Just as a biodiversity and landscape response to that corner.
So that's shown on the updated
And that's
plan,
shown.
which,
I've just found.
yeah, Commissioner Dave's just found it, so we must have it somewhere. You'll be relieved? Yes. Thank you.
Then moving around the site to the east, we've got some proposed exotic shelter belt type planting around that corner, which will reinforce. Then there's some existing exotic planting on that corner, but on the other side of the gully. And that will spring.
And is that where the site meets, Rambilly Back Road?
Yes, yes, that's where the existing plantings. So that will just spring some views that you get as you're travelling south down around the Back Road.
Yes.
And again, you will have noticed in your site visit that as opposed to the character of this side with the shelter belt, there's quite a feature. This is quite an open landscape. It has some very sort of scattered matagari and so on, but otherwise it's largely open. So we saw that, but also the road is very close to the site boundary and largely a sort of equivalent elevation. It is undulating, but a lot of it, especially that central part, it's relatively flat. So it presented a great opportunity for quite a generous buffer of native planting that won't have to get too high before it starts to have some screening effect, because you're in a car and you're next to the site boundary where the planting is, and then the solar panels are beyond that. And there's some indicative sections as we go through that.
What about roundabout? What width is that? Oh, do you want to show us when you get to the sections? Helpful.
Yeah, and now you can appreciate that at this scale, this is sort of conceptual. And the detailed planting plans we're proposing to come later. But that sort of buffer, it varies from, I think it's in the order of 10 to 10 plus metres in that, and gets obviously considerably wider to the south.
Thank you.
One of the other tweaks that we've made was in response to some the updated glint and glare modelling that was done, and we've filled in the gaps that we decided originally that there were enough layers of vegetation outside the site that screening that perimeter wasn't necessary, but on advice from the glint and glare experts, we filled that, proposing to fill that gap with vegetation and come around the corner here.
Is that native? Is that native?
Right, that is native, and this is shelter belt planting, so
So
higher.
yes.
These are also existing interior shelter belts, and as part of the landscape planting and maintenance plan, they'll be checked, and if there are gaps that need to be filled, that will happen as well. They're also a very important part of the screening and backdropping. And then the southwest corner, which you'll experience as you're driving north, predominantly up around Billy Naseby Road. that's where that second small waterway wetland is. So it was a good opportunity again to provide a very generous amount of native wetland planting and some tall species. And we'll also put some screening on the perimeter there just to, so as we're driving past, you get the benefit of that screening as well as the more distant, sort of like a layered effect.
Mm. Yeah.
I think that's probably.
That's very helpful, thank you.
They were the indicative species. They were the indicative sections that I was talking about. So you can see that we've got some heights on this side, 1 meter, 2 meter, 3 meters. So when you're sitting in the car, even when you've got plants that are just getting up to 1 to 1.5 meters, they're starting to screen. These break up those lower portions of the panels, which, while it's only like a partially effective screening, it's visually softening and providing a contrast to those platforms. So I would expect the effects to start reducing once you're starting to break up the appearance of that sort of form. But certainly once they get to 3 meters, the panels themselves are 2.8 when they're at their maximum height. So that shows
Thank you.
the effectiveness.
I think that's probably all we needed from the supplement. That's great. Yep, that's very helpful. Thank you. We'll just
It's quite advanced, but I think you probably haven't covered that.
Yep, thank you, Ms. Manaway. I did have one question for you at paragraph 10.6 of your evidence. And it relates to the receiving environment against which the effects of the proposal should be assessed. Yeah, so you've commented here that Mr. SB in his review of the proposal and your assessment pointed out that your assessment didn't draw on that in the same way. Can you talk me through what you're saying here and whether that had any bearing or change to your assessment conclusion?
Well, I'll just start. It hasn't changed my assessment conclusion, but I suppose it's sort of reinforce it. I think in some ways it seems more of a planning thing than a true landscape response, and I appreciate that. You know, there's always overlap, but I always, when I do my assessments, I like to err on sort of a first principles approach, if you like, and look at things from a landscape perspective first, which is why I went through the section 4 in more detail. I understand that at section 13 there is a reference to it being a complete code. So that has its own consequences.
Yeah, right. Okay. Thank you. That's clear.
I actually don't have too much more. You've covered most of them as we've gone through. In terms of the area of planting, do you have any sense of like the number of plants you're thinking or the square meterage of planting?
I don't about the number of plants. That will be through when sort of detail is needed, because there'll be a bit of a process to that. But it's about some 32 hectares in total
Yes.
of planting. But that is broken down into different types of planting. So, you know, there's a number of hectares that are the exotic shelter belt planting.
Yes.
Quite a large area of the mixed native species, and then a large area of the wetland enhancement planting. So,
Are those areas listed anywhere? Is that in your evidence or in the?
yes, I think they are broken down.
Okay.
Yeah, and it's not in my evidence than in my original, maybe not in my evidence, but in my original assessment.
Someone could help us with that. That would be great. Do you have any sense of the cost involved in that planting?
Sorry, I haven't. That's usually my landscape architecture colleagues who get more delve into that kind of.
Has Waffama School, to your knowledge, provided your client with likely costs of the planting?
Not as far as I know.
You don't have in a sense based on other examples or?
I don't, sorry, so it's, when it gets to that level of detail, that's my colleagues.
No, that's fine. Thank you. Yeah.
Yeah, thank you. That spurred a question I had. The 5-year timeframe to get useful screening, Mr. Espy has said in your paragraph 1014, after 5 years, it will start to have some useful screening. So I guess I was going to ask you, is that acceptable, from a landscape perspective, taking your point that it'll be progressively, lessening the effect, but and it relates to the question of cost really, because I know, as you go up a planter box size, the cost explodes, it goes up a lot. So is it just cost that would be the factor in not having larger plants put in at the start, or is there other reasons for it?
In the landscape planting and maintenance plan, we included in that table the recommended grades that they should be implemented at, and that well, a lot of those recommendations came directly from the nurseries and habitat restorations who we asked for advice on, because often, in fact, if you put in plants at a smaller size, they will do better.
More chances.
Otherwise, risk and shock, and imagine that's probably even more so in a climate like this.
I see. Okay. Thank you.
And in terms of the condition, have you looked at the conditions that have been, from the evidence? Yes. And so are you comfortable that they provide early enough planting to provide the required mitigation by the time the construction?
Yeah, I think it's condition 19, is it? Is where the certified final landscape mitigation plan must be implemented before the solar farm is operational. And in my original assessment, I'd said that I recommended that the planting be implemented in the first planting season following commencement of construction. So I suppose all things being equal, that's when the planting would happen during the construction.
So you've got 32 hectares of planting. Is it realistic that that would be planted in one planting season?
That wouldn't be just one planting this season. I think that would happen with planting seasons. And so perhaps part of the plan would be to strategically pick the areas that are the most sensitive and plant them first.
And I'm wondering whether there might need to be a bit more detail in the conditions that identify which are those priority areas, so that there's certainty in terms of effect mitigation of effect and the timing of that. And that noted down. So perhaps give that a thought and discuss the planner and in terms of the requirement, that would be helpful.
Just 2 matters. Firstly, as far as the reference for those areas that Ms. Manaway gave. So in the RFI response, we were looking at graphic supplement at the end of that document. Page 16 of that document, right near the start, has that table. So it's table 3 that outlines the various areas of.
Okay, great.
And then the other aspect, just as far as that most recent question, about the timing of planting. The other issue that Mr. Schlichting would be able to address you on is as far as getting the solar farm to the stage that it gets to financial close and then moves forward into construction. It's really important from Helios's perspective that the planting takes place during the construction phase rather than requirements for the timing of planting to be in advance of that. And so that's certainly something that we can address you further on, but that the proposal is that it happens during construction, which is really important from the commercial perspective.
So just so I'm clear, you're saying that the funding arrangement, so you presumably, if the consent was granted, go into your detailed design, the funding arrangements are secured, and then you start construction, and at that time, your client doesn't want to have any pre-planting obligations before construction starts.
That's correct. Yes.
Yeah.
And so just like doing is probably the best
Yeah,
way to speak to on
Yeah,
this.
that's fine.
But that is a really important aspect that's come up in a recent project. And so it is an important issue. And so I want to make sure that that is clear to you and making any decisions about the level of detail and those questions around priority planting areas and the like. That is the other aspect of it that is important from Helios' perspective.
And can you just remind me how long construction is expected to take?
2 years of it.
2 years. So the earliest you're going to have is 2 years. So I guess I'm thinking about timing. If you're going to need more than one planting season to plant this, then
There are 2 planting seasons a year essentially.
oh, okay,
Yeah, spring and
right, okay. And so the most you'll have is 2 years growth. Do you have a sense of what the areas of priority would need to be to such that your conclusions around effects will be achieved?
in fact, I think I've already, I can't remember if it was in my evidence or in my original assessment, but I think I recommended that to start with, at least the area to the north. Because that was where that open area to the north of Ranfield and Mansfield Road, where there currently is no screening, and also won't take, because again the land is, the elevations are quite similar between the road and the panels. In level, the height they won't take too much height for them to start having some effect on softening the built form. So I think that would be a good area to start with, and also infilling one of the shelter belts, the internal shelter belts, that will help ensure some additional stream from line 4. And you can see that in the photographs that's in the photographs.
And so the reference for those priority recommendations from Mr. Manaway, that's section 6. Again, that same document as well, page 60. So there's a series of bullet points there.
Okay. So just to flag, it'd be useful to consider whether that more of that detail needs to be worked into the conditions. So just for my benefit though, are you confident that if those priority areas were, say, planted within the first year, once construction begins, are you confident that the effects will be managed to the extent that you've assessed them to be by the time construction finishes? So over essentially just within 2 year period.
So effects, I would expect landscape and visual effects to be a trajectory over time. So as the construction activity occurs, the effects will rise, and as that finishes, as the planting grows, those effects reduce. It's not a hard line. However, because the activity on site were stopped, because the planting in some of those key areas were had some time, they won't be they won't be particularly effective in terms of screening at that stage. Perhaps the very lower aspects of the solar panels. That would be it. But you would have a broad buffer of planting in the foreground between you and the built structures, softening and providing softening of that visual contrast, which, in my opinion, does start to reduce those effects following construction.
Thank you. Anything? That's great, thank you. We'll call a lunch break. We'll come back at 2:00. Thank you. Yep, all right, we'll make a start, thank you. We do have just a couple of questions for Ms. McManaway, if we might call her back, please.
Absolutely. And I've also got a couple of other little updates. So
Yeah.
making your way up.
Yes, why don't you do that? Okay.
So firstly, if I could take you to condition 18, and this is of the applicant's version, plain or track, it doesn't matter, attached to Ms. Van Hitty's evidence.
Just a minute. Yep, 18.
So two things. Firstly, about the question of prioritisation. So condition 18A1.
Yeah.
Require or cross references to the recommendations identified in section 6 of the 28 February 2024 landscape effects assessment. That's that reference I took you to previously. So there is a link, but certainly understand if there was a concern about making it clearer, those could be transcribed directly into the condition.
Yeah.
But there is already a link there.
Thank you.
The other matter, and Mr. Denise will be able to talk to you about this, is Roman 4 about the plant flammability proportions.
Yes.
There is a missing word. It should be the native species mix or the indigenous species mix. So those proportions will relate to the range of indigenous species proposed rather than also the shelter belts as well.
So, Romans 4, the first, and then it should say native species mix shall, yeah.
Yes.
Okay.
And then the other updates, just in relation to the questions regarding the cost of planting, just because this
Yes.
may be relevant to questioning for other witnesses. So Helios's budgeting, and so Mr. Schlichting can also speak to you about this to the extent you've got questions, has $1.65 million allocated towards planting. For 32 hectares, that works out to approximately $50,000 per hectare. And so Dr. Morris will be able to speak to you about, he's spoken to some of his colleagues as far as how that compares, but that tends to be in the order of 5 to 20,000 per hectare for revegetation. So there is a significant budget that has been put towards what is contemplated. Now, very happy for you to be direct questions
Yeah,
for the right witnesses, but just wanted to make sure that you have that information available to you.
Yeah. So we do have a couple of, if we could have Ms. McManaway back briefly, apologies. And I have a couple of questions that may be for you and they may be for Dr. Morris, but I'll start with you and see where we go. And actually this one does relates to your evidence. So, paragraph 7.16. And here you're talking about, potential visual effects and so on. And at the end, your last sentence is, it is also emphasised that the effect of a change in available views is not automatically adverse. And I just wondered if you could expand on that, and do you mean from different people adverse? So the question about is it adverse or not? Do you mean from different people's perspectives or values as a personal perspective, or do you mean from different viewpoints?
I mean, from a technical assessment point of view, which I guess incorporates those things, because an assessment of visual effects doesn't just, you're not just looking at the change, the magnitude of change, you're assessing it against the set of the context that it's, and when it comes to visual effects, that will include the very specific viewpoint and the setting that you're looking at it within, as well as the viewing audience. So there's a range of considerations. But yeah, change in itself isn't necessarily a negative effect.
Yes, and so I've got two follow-up questions from that. One is, do you accept that members of the community may have differing views about whether a visual effect is adverse or not? I mean, presumably someone might go, oh, cool, it's a solar farm, that's interesting. And someone else might go, oh, that's awful, I really preferred the open paddocks. Is that, do you
Yes,
accept
and that happens, you know. It's not just solar farms. Many projects have been involved and gives a broad spectrum of views, exactly as you just described.
Yeah. And in this case, note that down. And in this case, you've said it's not automatically adverse, but I think your conclusions are that the effects will be adverse visually. So what's the point of saying they're not automatically adverse? What was the point of putting that in your evidence?
I suppose because maybe some people assume that it is.
Yeah.
So just making that point that it's a broader consideration. Landscape is always changing. You're inserting a new change, and in this case, at a large scale. But you still have to go through an assessment process. We follow a methodology that has quite comprehensive guidance now put out by our professional institute. So yeah, I think that was
Thank you. And so the other, and Mr. McHennick's obviously clicked onto that. We're quite interested in this planting and the scale of it and how manageable it is. And I've got some questions, whether it's for you or Dr. Morris or even Mr. Shidler. Well, I'm happy for any three of you to answer these. So the first question relates to pest control. So I think in the conditions it refers, and this may be Dr. Morris, but that refers to weed control. There's a bit of an interchangeability around pest control versus weed control. And I wanted to understand, are you proposing both weed control in terms of pests and animal pest control? Are both necessary and are both proposed?
Yes, for different reasons.
Do you want to come up? Thank you.
Fair to say up front that in terms of pest control for both browsing animals that are going to be a nuisance for restoration planting, so possums or that kind of thing, or for predators that will be a problem for fauna. It's fair to say up front that the detail in that will come through not only the further development of the landscape plan, but also the wetland restoration plan with input from Karunaka and from DOC. But we, in respect of predator control, have recommended that to Helios as an enhancement, not on an effects basis, but as an enhancement. And my understanding is that they have undertaken to that in terms of possums and the like. That's probably more in the camp of Elizabeth Manaway's planting areas.
Yes, need to check because the landscape planting and management plan was prepared by my colleagues, but it does include pest control and weed control. So it's
Okay.
separate.
They're both listed separately. And in the
Condition
condition,
18A3 does refer to both weed removal and pest control.
so when you're talking about pests, that's animal pests,
In rabbits and
wherever, yeah. So condition 18,
A Roman 3.
thank you. And this may be either of you or for you, sir, in terms of plant supply, so you've got 32 hectares worth of planting. Where is that coming from, and how confident are you that you have the local supply that you need to do that? Who's best to answer that?
Well, as I mentioned earlier, part of the commitment that we make is to procure locally to the extent possible. So,
Yeah,
a canvassing nurseries in the region and then beyond would be part of the landscape plan if we finalize the detail. I can't say personally which nurseries specifically we would source those from. That is a large undertaking as you cite. So again, our focus is to procure as much locally and then work out from this region to the extent necessary.
can I just?
yes,
think the fact that, well, actually to start with, in conversation with Mr. Morris at the lunch break, we realised that that number 32 some hectares included a full calculation of the wetland area, and in actual fact that doesn't need fully dense planted areas, so that would cut down
Like a third or so.
okay. That's useful.
Calculation was about 11 hectares, so that would reduce considerably. Also within those numbers, there's a significant area of the exotic belts, and I would imagine that you might get those from a different nursery, for example. So you're not asking in one type of nursery to provide the same.
Yeah. It might be helpful in the reply to cover that, in terms of particularly the natives that have been recommended. It's your recommendation that they are locally sourced species? Yeah, so it's how realistic is that in terms of the scale that you've proposed to get locally sourced, the volume of those plants and the time frame that's. I've just as an example, I've been involved in other projects where the applicant consent holder has actually had to establish their own nursery, and that has been part of the conditions of consent because for this reason. So I'm interested in whether you could rely on existing nurseries to be able to provide the volume of the type that you're recommending.
Yes, and condition 18A Roman 8 talks about consideration of local seed sources for screening planting. So it is, and their suitability where practicable. So there is, it's not a blanket, it all has to be sourced from a nursery within X kilometres of the site or something like that. So,
Yeah,
but certainly understand the point.
yeah. And you're comfortable with that wording condition?
Yes, I am. Having had input into the planting list, was mindful of not including anything too obscure or unusual, such as it would be outside the ordinary expertise of, typical native plant nurseries.
Yeah.
So while this is on a reasonably large scale for a native planting exercise, it's not on an unheard of scale from the projects that I've seen promoted and delivered elsewhere in the South Island.
Okay, thank you. Thank you. That's everything, and so that's all for you guys. Thank you very much. In terms of information, we would be interested in getting, if you could provide us with copies of the 2 resource consents you mentioned that Helios have obtained from solar farms around in New Zealand?
Certainly.
Thank you. Right. Anything else? No, right, thank you. So we have Mr. Ibbotson.
Yes, so we're going to move to the online component of the hearing.
Right.
And so it is Mr. Ibbotson in relation to noise.
Yeah.
Hello, commissioners and everyone in the room. How's
Can
my
you hear
audio? Can everyone hear me?
Yeah, we can hear you. Can you hear us okay?
I can hear you very clearly. Thank you.
Brilliant. Thank you.
So, would you like me to go through my executive summary?
Yes, if you could read your executive summary, and then we do have some questions for you.
Sure. Okay, so my evidence provides an overview of the noise generating aspects of the project, including an assessment of noise following removal of the battery energy storage system component of the project. The results of my assessment of noise effects shows that noise levels from the solar farm will be very low at all surrounding dwellings. The loudest rating noise levels at the compliance receivers over the daytime would be 11 to 26 decibels LA10 during peak operation. And this would comply with the Central Otago District Plan daytime noise rule of 55 decibels LA10 by a significant margin of at least 29 decibels. The daytime rating noise levels from the solar farm would be much lower than the existing ambient noise levels that I measured around the solar farm during my noise survey. The loudest possible level of solar farm noise emission may be similar to the existing background noise levels in the area during still daytime conditions. Operational solar farm noise levels within the Naseby and Ranfurly townships will be entirely negligible. Construction will occur over a period of 24 months. The loudest construction activity will be piling to support the solar panel arrays. The closest dwellings are approximately 500 metres from the closest part of the solar farm array. Construction noise levels at these dwellings will be in the order of 50 decibels LEQ during piling. And compliance with the New Zealand Standard 6803 guideline of 75 decibels LEQ will be achieved with a margin of approximately 25 decibels. And thus the district plan noise limit, or the construction noise limit, will be readily complied with. Noise from the closest...
Sorry to interrupt you.
Yes.
The 50 dB LAQ, is that, how comparable is that to the 55 dB LA10 in the district plan rural resource area rule?
LEQ and L10 noise levels are normally very similar, and you can largely treat them as such. The difference here is that the operational zone noise rules that apply to the zone are given in LA10, and the construction noise limits are given in LEQ. But for all intents and purposes, and for most sources, unless they maybe only occur over a very short period of time, the LEQ and the L10 noise levels are very similar. So when I say that construction noise will be in the order of 50 decibels LEQ, it's quite similar, in fact, to the 55 decibel, slightly quieter than the 55 decibel LA10 noise limit that applies to rural activities within the zone.
So, you're saying then that your expectation is that the construction noise will comply with the general rural zone standard as well as the construction noise standard?
So to put it very precisely, because construction doesn't have to comply with the zone rule, it only has to comply with the construction noise rule. It will comply with the construction noise rule by a significant margin. And yes, in fact, the level of noise from construction will be below the level of noise that applies in the zone.
Thank you.
Notwithstanding that rule does not apply.
Yes, I understand that, but I
Yes.
still want to ask a question. Thank you.
Yes, sure. Okay, so just to continue, noise from the closest piling areas to the nearest dwellings will be audible at these dwellings, but noise will be at reasonable levels. When piling is occurring at areas of the site more distant from these dwellings, noise levels will be lower. The construction noise levels within the townships of Naseby and Ranfurly will be negligible. Several submissions reference noise. Many submissions have been received from those living in Ranfurly and other locations at greater distances who have raised concerns about transformer noise. I've calculated noise from the transformers using appropriate engineering principles. I consider the submitters can have certainty they'll not be affected by transformer noise due to the significant distances between the proposed substation and the dwellings and the low overall transformer noise levels. I've responded to other submission points in this evidence. The conclusion of the Council's Section 42A hearing report that the proposed activity should be granted consent subject to appropriate conditions aligns with my view. I've addressed matters raised in the Section 42A report, such as transformer noise levels and the need for acoustic barriers, which are not required. Mr. Vincent and I differ in our views as to the appropriate construction noise limit to apply, that being whether the long-term limit in New Zealand 6803 or the typical noise limit in New Zealand Standard 6803. However, as the project will comply with either of these by a significant margin, I do not consider this as a determinative point. I've reviewed Council's proposed consent conditions. Given the margin by which construction noise is predicted to comply, I do not consider there's utility to a construction noise and vibration management plan being prepared at this time. Similarly, ongoing noise monitoring for construction noise does not seem warranted to me. Should the panel consider monitoring during construction is warranted, in my view, this should be restricted to an initial period to demonstrate that compliance is and can be achieved as expected, rather than ongoing monitoring to no point. I consider the version of the proposed conditions of consent appended to Ms. Benhedi's evidence are appropriate for controlling potential acoustic effects from the construction and operation of the project to reasonable levels. Overall, the project would result in low operational daytime noise emissions and will operate at a level of noise that is considerably below any recognised national or international environmental noise guideline for the protection of human health or amenity. Under standard operating conditions, the project will not make noise at night. Construction noise due to piling will be audible at surrounding dwellings at times, but noise will be considerably below recognised construction noise guidelines, and I expect construction vibration to be imperceptible at dwellings. Thank you.
Thank you, Mr. Ibbotson. Got some questions, but my understanding of your evidence or the themes that's coming through your evidence is basically that you relied on the district plan parameters or rules for different construction noise standards and the district plan operational noise standards, and your case is that you comfortably comply with all of those standards. That's the general sort of theme. And then you have got some evidence on different standards that have come in, and you've discussed where you differ from the officer in terms of which are the appropriate standards. So I think I understand the thrust of your evidence, and I was just going to ask you a couple of questions. When you're relying on district plan standards for a very large site and a 24-month construction period, like pile driving, is it reasonable for residents in the rural area, for instance, to anticipate first of all, a 24-month construction period? And they wouldn't expect something of that duration normally, would they? But is it your evidence that because the site's large and you refer to it as a mobile construction activity, do you mean by that it moves around the site, it doesn't all happen at once? Is that the key point, the key distinction to make there? Is that your evidence?
Yes. So to answer all those questions, firstly, the mobile plant that is typically used on a solar farm, and what I always assume will be used on any solar farm site, is a specific piling rig which is highly mobile. As I understand it, I'm not a construction manager, but as I understand it, it's very important that construction proceeds quickly, because the cost of a solar farm is largely in how quickly it can be constructed. So piles are set out and the piling rig moves quickly from place to place, and the intention is that piles go in as fast as possible. And what happens is the piling rig does move very quickly from location to location. So you typically don't get a piling rig being in an area in a small area for any more than a day, and then it will move away. Of course, this is a large site, and the residents are quite far away, so piling will obviously move away from those dwellings somewhat more slowly than it would if the dwelling was right next door to the solar farm site. But the point is that New Zealand Standard 6803 certainly does anticipate construction activities that could be of this duration, and it has various noise limits that apply based on the duration. So if your construction activity was only over a few days, say 15 days, then a higher limit would apply. If it was up to 20 weeks of construction, then a medium noise limit would apply. And if it was beyond 20 weeks of construction, then a lower noise limit would apply. But the standard is also quite clear that where activity moves around a solar farm, a construction site, that it is the location of the construction that informs how the duration should be considered and what limit should be applied. So there's other cases, solar farm hearings where there's been an agreement that the typical duration noise limit should apply to these activities, because that's it's very clear from the standard in my reading that that's what the standard intends for those limits, to those typical duration limits to apply to solar farm activities. But it's really just an academic matter here, because the solar farm activity on the site will comply with all of those limits. There's no question that it will comply with any limit from that standard that you might choose to pick out. So if you chose to apply the lowest limit in the standard during the daytime, then the construction on the site would comply with that with a significant margin.
Yeah, that's understood. We understand that evidence, but Mr. Vincent has, assessed it differently. But just as an academic thing, why would it not be the long-term noise standard applied to construction that goes over 24 months? Would that not be a clear-cut case of applying the 5 decibel lower limit because it's a long duration noise?
There's very clear direction in the standard, and I'm happy to send it through, or if you like, I can pause and find it now and read it to you. But the standard says that where activity is moving from, where activity is not static within a construction site, where it moves from location to location, that it is the noise effect from that area of the operation which should be used to determine the duration for which the limit should be applied.
Okay, understood. That goes back to the previous question about it being a mobile operation. It moves around the site. Okay, understood.
Yeah.
Look, I haven't got a lot of other questions. I understand the premise of your evidence, but just to confirm, sound propagation has been, you've said in your evidence you've built that in, factors to do with topography. You've assumed that there will be sound propagation in your modelling. Is that correct?
Yeah, sure. So our model is quite detailed. It includes all of the topography, although, as you'll be well aware, the site is quite flat in general, sloping down towards Ranfurly, but flat in general. In terms of meteorological effects, the calculations I've made are very, and the propagation that occurs from that, the calculations are very conservative. They assume what we call an enhanced propagation situation, where sound essentially bends down in a temperature inversion or a downwind situation. Those conditions occur much more seldom than the typical situation where you don't have a temperature inversion, which are the conditions where the solar farm will be generating the most power. So the model is very conservative in its assumptions and represents the worst case sound propagation. And so what you can take away from that is that in most situations, noise levels will be even lower than the low levels I've already predicted.
Thank you. And just one question of clarification. There's a table you've produced at paragraph 7.4 in your evidence. It's no page number, but it's just before 7.4. And I think that's to illustrate the point you're making about the BESS battery storage system being removed, which reduces some of the nighttime noise. Is that right-hand column that's sort of greyed out, are they the figures that would have been in place if the BESS was operating, or is that the amended figure I couldn't quite understand that, sorry.
So that's the potential noise level that might occur during the night period. And by night period, I mean before 7 a.m. So it's the assumptions there is that there is some movement of there is some operation of the inverters, either because there's a very low level of solar gain, which causes some current to flow, or there's what's called VAR. The inverters are working basically to provide reactive power to the grid. I can go into that if you like. It's
I know, just to confirm, that's the other figures without the BESS system. You've taken that out.
Without the BESS
So
system, that's right.
So there's still a level of noise, but it's lower. Yeah, okay, understood.
Lower, yes. Yeah.
I think that's all the questions I've had, actually. Yep. Yep.
Thank you. Just following up from Commissioner Ray's question around the noise over the 24-month period of the piling. In paragraph 1.3, you've stated noise from the closest piling areas to the nearest dwellings will be audible at these dwellings, but noise will be at reasonable levels. When piling is occurring at areas of the site more distant from these dwellings, the noise level will be lower. Do these assessments or standards that you rely on consider the repetitive nature of a sound across a significant period of time, and whether that would whether those sounds as received may be enhanced or amplified due to their repetition over a time period for a person?
The New Zealand Standard 6803 relates to a wide range of construction activities. So it would include, it is regularly applied to piling activities, drop hammer piling, vibro piling, and board piling and other sources of piling noise. So it's really not unusual for piling to be a part of how construction noise is assessed. In my knowledge, there's been no real question across other projects which might involve piling that the construction noise standard is appropriate. And your point, is well made that the activity does involve piling over a longer period than possibly a small wharf or something like that. But in its heart, it's construction noise, just like any other form of construction noise. And because we are predicting noise levels that are so much lower than the limit, I think that should give you confidence that those, what we might otherwise call special audible characteristics, the more annoying nature of certain activities, will be addressed just by the generous nature of the compliance.
Thank you. What did you call that term for annoyance? This term's not included in construction noise standard, but in other acoustic standards, New Zealand Standard 6802, there's a term called special audible characteristics. And so that means that if you have an activity which is particularly intrusive, so that might be something that's really tonal, like a saw, which has really tonal points and sort of sets your teeth on edge, or has a very low frequency component that's particularly intrusive, that's penalised. And what the standard does is it penalises the noise by 5 decibels to take into account the increased annoyance of it. And so that isn't something that the construction noise standard does. But I think, as I said, you can have confidence that because we are 25 decibels below the limit, that should more than satisfy that part of the annoyance factor. Thank you.
Thank you very much, Mr. Emerson. Really appreciate your evidence.
Thank you.
Right, the next witness is Mr. Logan, who's also going to be joining the teams.
Can you hear us, Mr. Logan?
Yes, I can, Commissioners. Can you hear me well
Great.
off?
We can hear you perfectly. Thank
Fantastic.
you very much. If you're able to read your executive summary and any other things you'd like to bring to our attention, and then we have some questions for you.
So I'm project engineer with ITP Renewables. I've been involved with this project since the early stages from May 2023. I haven't conducted these glare studies myself, but I direct them, I review them, and I approve them. And I've overseen all the subsequent clarifications and additional analysis that's been conducted since the original study, including the moonlight glare assessment and some assessment of the minimum amount of vegetation screening that's required. So the glint and glare assessments are conducted using a piece of software called Forge Solar, which is a de facto industry standard. And the models were based on the layout designs for the solar farm and the mechanical details of the tracking structures. And then we build in topographic data from Google Earth and then add in receptors that way. The model includes a limitation to the backtracking of the solar farm in the early mornings and late evenings, which we've set at 10 degrees as a method of mitigating glare, and I'm happy to explain that more in detail if required. And the other mitigation measure is additional vegetation screening, which has been mentioned earlier today. Our modelling concludes that there's very little yellow glare on the road network. Yellow glare is typically what we consider to be a potential safety hazard. So between the backtracking and the vegetation screening, there's very little residual glare, and we consider the remaining green glare to be not hazardous and doesn't require further mitigation. So based on that assessment and based on the resulting glare, it's my opinion that the glare effects are less than minor, and that with the proposed condition 29 for the glint and glare, I believe it's active management plan, I think that's an appropriate way to manage any unforeseen glint and glare issues in the future. Happy to take questions.
Right.
Yeah, jump in. Yeah.
Thank you, Mr. Logan. In para 1.4, you've written, our modelling concluded that all residual yellow glare to the road network is eliminated. But when you just spoke to that, you said very little was it? Sorry, I forget from the wording. You actually used some different words and essentially said they'll be reduced or something of that ilk. You didn't say that would all.
Sorry. So yes, to clarify, so with both the backtracking and effective vegetation screens, then our model has no yellow glare on any road or dwelling.
Right. So just to be clear, your wording in paragraph 1.4 is correct.
Yes.
Yes. Okay. Thank you. That's right.
Yep. Yeah, thank you. I just had a couple of questions, Mr. Logan. 7.5. Yeah. So in that topic, in paragraph 7.3, before that you have a heading called sunstrike and glare impacts for visual amenity. But in that assessment, you focus on safety. Impacts other than amenity. I'm just wondering where you've drawn your conclusions that there won't be a visual amenity impact, noting that the landscape witness, Ms. McManaway, is relying on your evidence to deal with the amenity issues. So maybe you could just summarise what the impacts on visual amenity are from glare.
Yeah, so generally, glare gets treated in sort of two different ways depending on the nature of the receptor. So for residential dwellings, typically you will consider amenity rather than safety. And the usual benchmarks for that are based on total duration of glare. So I'm not aware of a standard in New Zealand, and there's no sort of definitively agreed standard anywhere. The guidelines that we use are based on similar sort of analyses for wind farms and shadow flicker. And that's 30 minutes a day or 30 hours over a year. And no, with the mitigation we have, there's no receptor that receives any glare anywhere near that. So that's the basis for that conclusion.
Okay, thank you. In terms of the glare impact on non-commercial pilots, paragraph 716, you've assessed the impact on agricultural pilots, aerial pilots, rescue pilots, etc., for the helipad at the Ranfurly Hospital. Have you assessed the impact on just general aviation, or is it just that one route that you've assessed?
It's just that one route, and the reason so typically you focus on takeoff and landing, because that's the only real time that aviation is likely to receive glare. So runways, helipads, sometimes private runways. Often we're guided, because we do a sort of visual search of what we can easily find, and then we'll be guided by our clients on what other things to include. So we don't do a general sort of inclusion of flyover, because those aren't the times where pilots are exposed to glare. And you could include a flight path in sort of any direction. But there's the two reasons are, one, that you don't is, one, the hazard is greatest at takeoff and landing, and two, generally there's a limit on the vertical view of pilots. And so when you're flying, you probably won't even see the solar farm a lot of the time.
Thank you. In terms of vegetation screening, you made some comments earlier that you've been liaising with the landscape witness about that. Paragraph 720, you've made the comment that vegetation screening will need to be planted with sufficient depth to appear essentially opaque. That, in your view, has that been implemented in the landscape plan and conditions?
It's sort of a question for, ultimately, we're pretty limited in what we can model, because Forge Solar only implements this opaque barrier. And we rely on then the vegetation screening effectively matching that criteria. So I'm not an expert in vegetation screening. I haven't reviewed that in detail. So we're sort of approaching this from the point of view of saying, to be transparent, this modeling has this limitation, which is that it has to be opaque. And then if you want the modeling, like the reality to match the model, then the vegetation screen has to approximate that.
Okay, thank you. Just one further question from me, thank you. And that's in relation to the conditions about setup to eliminate glare, various measures to eliminate glare, and you've taken issue with the officer's suggestion that there be a project setup condition to allow that to happen. I just don't understand that. I just wanted you to take us through what the concern was about that, and how would you determine glare at the project setup time anyway until you've monitored it? And I just didn't understand that. Sorry.
This is in relation to striking out physical alterations to the solar farm setup.
Yeah, 9.2. It's in your paragraph here.
Yeah. So I think really there's the ways that you can. The main variable that determines how much glare you get is the angle between sunlight and then the receiving surface. And ultimately that can always be managed by changing the tracking algorithms, or even having specific times where you program in at this time for this specific reason we're going to deviate from the standard tracking arrangement. And that's a pretty that's a way of eliminating specific glare hazards without having to change the actual layout of the solar farm. The other reason to probably be a bit cautious about it is that it's quite hard to determine, as you say, like it's really hard to determine glare impacts with absolute precision. And you probably won't discover that until the solar farm's been built. And then if it's a choice between removing trackers or removing modules and changing the tracking algorithm, I can't imagine any scenario where any operator of a plant would want to remove trackers or modules. You would just change the tracking algorithm. And if you don't want to change the tracking algorithm, then you can go to vegetation screening. So the only reason to remove it is I think it's unnecessary.
Right. Yes, thank you. I think I understand that now. No other questions from me, thank you.
Thank you, Mr. Logan. That's all we had for you. So thank you very much for your evidence and for answering our questions.
Welcome. Thank you very much.
Thank you. So back to in-person presentation. So it's now Mr. Denise in relation to fire risk.
Afternoon, Commissioners.
Good afternoon. Just one moment.
I might have one, but I'm not sure it's two.
Thank you. We had actually let your legal counsel know we didn't have any questions for you. You're very welcome to be here, obviously. And if you'd like to run through your executive summary, that's fine. I actually then thought of one question, so it is quite good that you're
We
here.
probably will we'll think of something, yeah.
So don't feel you're not welcome at all. So
Yeah, there is.
yeah, we're in your hands. Thank you.
Okay, my name is Hamish Denise, and I'll read through my executive summary of my statement of evidence dated 21st of July. This statement of evidence is given in respect of the resource consent application by Helios for the proposed solar farm at 48 Ranfurly Naseby Road, Naseby. I was engaged through my employer Becker Limited to provide fire risk commentary and advice into the development of fire risk mitigations. A range of fire risk mitigations have been adopted by Helios and developed into practicable proposed consent conditions by Helios and its team of consultants. These fire risk mitigations include appropriate certifications and design standards for electrical components. Point B, fire risk management plans for the construction and operation stages of the solar farm. Point C, a fire emergency response plan. Point D, firefighting facilities, including water and accessibility, including a new perimeter access track, which improves firefighting access and resists fire spread. Point E, limiting the flammability of the vegetation. Fire and Emergency New Zealand, FENZ, has been consulted by Helios throughout the development of the project to date and was provided a draft version of the proposed fire risk mitigations. Their firefighting advice has been incorporated into the proposed mitigations. FENZ has confirmed that the process for certification of the fire risk management plans, including fire emergency response plan proposed by Helios, is an appropriate approach. The proposed fire risk mitigation measures reduce the probability of fires and their preceding conditions occurring via compliance with electrical standards and fire risk management plans. The proposed fire risk mitigation measures also reduce the potential consequences of a fire if one were to occur through resistance to grass fire spread provided by the network of internal and perimeter gravel access tracks, facilities for firefighting intervention, and fire emergency response plan.
So now I have two actually questions. The first one relates to the FENZ correspondence, and you attached email chain with them to your evidence.
Yes.
The top of the chain, the email from Bobby Lamont, Monday, 21st of July, to you and others, refers saying that the wording looks acceptable and that they would be meeting with Naseby and Ranfurly Brigades this Wednesday night to seek feedback, and can relay these back to you once collated. Did you receive anything back from them on that?
Yes, so Bobby's email came in at 8:30 the morning of my statement of evidence.
Yes.
So I managed to attach that.
Yeah.
He then met with the Ranfurly and Naseby fire brigades and provided an email back to us. Basically, the summary of that was it was a positive meeting. They raised some of the questions about site access, site maneuverability, and water tank locations, and a few other things. And Helios responded to say, we can sort those things out in the operational and management plans. And that I suppose that's a summary of the email trail that came after my statement.
Thank you. And maybe it's not for you, but I guess the question will be, do the conditions cover the weeks that FENS are looking for? We can come to you when we go through the conditions. Yeah. That's fine. My second, I guess it's just a general question. You will have seen in the submissions from local people that they are concerned about fire risk from the site. It's obviously a very dry area, and you know they are concerned about fire risk. Are you confident that the mitigation that you've proposed and that will go in through the management plans will protect neighbours from fire?
Yes, I can answer that. Like the risk to neighbours is a combination of probability and consequence. I suppose on the probability side, when you look at statistics of solar farm fires, the lack of quality components, lack of good install practice, or lack of maintenance, that's the normal thing that causes fires. And the conditions deal with those good practices and procurement, construction oversight. On the consequence side, a key, apart from the electrical components, which I suppose form the ignition risk, the vegetation is the fuel load of the site. That's the grass, existing shelter belts, and new screen plantings. And when you look at the vegetation controls in there, we've got all these practicable measures in there. So the grass height will be controlled to an agreed limit that's set in the operational management plan, and FENS will have input to that. As an example, because grass heights come up in the submissions, this isn't a site that's going to have haymaking. There'll be no situation where a tractor drives along an access track, mowing the side, and a hay baler built. You know, the length of grass for hay, that's too much of a fire risk. So that just wouldn't exist. I think apart from the grass itself, all the new native species, so wetlands and the native tree screen planting, you'll see there's FENS have a list about 400 species. They've categorised them into very low, all the way up to high. We've worked with Boffa Miskel to coordinate the majority of species sort of at the low end, noting that survivability is a bit of an issue. So of species, so the new screen plantings are also effectively as least flammable as they can be. And when you add up like lowering the probability, dealing with the consequences, and I've insisted on this 4 metre wide perimeter track internally, which wasn't there before. If there is a vent, it gives FENS basically unencumbered access all the way internally to arrest fire spread as much as they can at the boundary. A lot of the boundaries actually have another road, like the one Sue was pointing out before that had pine trees up it. You know, there's another road there as well, which is another, I suppose, defendable position to FENS. But I felt we still needed a 4 metre wide one up the inside of the site so that, you know, hopefully there's almost a double fire break there.
So you've got the 4 metre perimeter setback, plus in some cases a road.
Yes.
Actually, in quite a few, most of the boundaries.
Yeah.
And that provides that sort of buffer for fire stop as required, I said. Okay. Okay.
And with the species mix, we it was raised before that a word was missing, that the species mix was for native species in the amended planning conditions.
Yeah.
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 It doesn't apply, so it doesn't apply to the infill belts and stuff like that.
No, that's lovely. Thank you. Thank you for your evidence, answering our questions.
Next up is Mr. Copeland in relation to transport.
Yeah. Well, thank you.
Good afternoon, commissioners. My executive summary is very brief, so I'll just reread that and go into questions.
Thank you.
So, my name's Logan Copeland. I'm a transportation planner for Adelaide. My evidence is provided in relation to traffic and transportation matters. In summary, subject to conditions, adverse effects relating to safety and efficiency of the transport network will be sufficiently managed during construction and operation. My conclusion is formed on the basis that the traffic flows in the surrounding road network are very low, and even during worst case construction traffic periods, the additional traffic is within the capacity of the transport network. With the implementation of a construction traffic management plan, CTMP, including a range of ongoing traffic management measures, I do not consider that construction traffic from the project will lead to unacceptable adverse transport effects. During the operational life of the project, traffic generation levels will be very low and are unlikely to be noticeable to other road users. Therefore, no mitigation is required to manage operational traffic effects from the project, but ongoing mitigation is required to manage effects arising from glint and glare on road safety. Subject to minor amendments, which are contained within my evidence, I support the conditions of consent relating to transport included in this instance, section 42A report.
Thank you. And the amendments that you've recommended in your evidence, have you noted whether they've been captured in the planner, in the entrance planners?
Yes, I'm
Check that.
fairly sure they have.
She's nodding. But
Yeah, yes, yes.
Right. Okay.
Yeah, I've got three questions. It's Mr. Copeland, isn't it?
Mr. Copeland.
Spelt without an E, but it's Mr.
Thank you.
Copeland.
Yes,
Okay.
most people say Copland. so
Okay, I was about to. Anyway, thank you for that. Yeah, just had a couple of questions. In terms of the impacts of glare, I know you're recommending a glint and glare adaptive management plan, and I took from Mr. Logan's evidence that he didn't really think there'd be an impact on glare with all the other measures put in terms of driver safety. But is your approach more of belts and braces type approach, just to build it in for safety?
Yeah.
Okay.
Essentially, yeah.
Right. Okay.
So, my assessment of glint and glare is relied upon Mr. Logan's modelling,
Yeah.
and then we've used that to
Okay.
make a determination on what the effects of that are on road safety, and the conclusion is that yellow glare is, in my opinion, unacceptable on the road network and should be avoided.
Okay.
And I'm comfortable with the conditions that will achieve that. The condition relating to the management plan that you referred to, it is a belts and braces approach that I guess recognises that, and again, I'm not an expert in that field, but the potential uncertainty in terms of what might happen versus what's been modelled, and it gives the ability to adapt and make changes to make sure that, from my perspective, yellow glare does not get onto the road network.
Thank you. And another question on the road pavement effects. You're encouraging the construction traffic to use the sealed roads, the state highway, because they're built for it, I think, in your evidence. And would you have had a concern that trucks using the back road would cause a lot of dust and that sort of thing, or was it more that it would cause damage down there? What was the concern
Well,
with them using that area?
So so we recommended that vehicle access is obtained from the sealed road network. And the primary reason for that is, well, the road, Grenfell-Naseby Road is a higher order road in the district plan. So as part of that, it's reasonable to conclude that heavy vehicles would use the road. Conversely, Grenfell Back Road, very low volume, unsealed road, and that's a commonly held view amongst transportation professionals that if you overload roads like that aren't designed for it, it's likely to cause accelerated damage. In terms of dust, it's not really a traffic matter, it's more of a amenity matter, but yes, that would be a potential issue, I suppose.
So they're likely to have an impact on the road surface, or the state highway is able to handle anything that's thrown at it? You know, is it going to lead to deterioration of the road surface, do you think?
Well, I'm not a pavement dealer, but as I was saying before, the state highway network is part of its role is to carry freight, and so it's reasonable to conclude that adding heavy vehicles to it are less likely to result in accelerated pavement damage compared to, say, a lower order road.
Right. Okay. Thank you. Understood that. And just also,
so that's the state highway, but what about Grenfell-Naseby Road, for example?
Yeah. So the same logic applies. Is that it's a I think
materials.
It's a collector road. It's got a specific term in the district plan, which escapes me right at the moment. But yeah, I guess the approach to access has been to direct access onto Grenfell-Naseby Road because it's a higher order road, and relative to other frontage roads, the potential effects on pavement are therefore less significant.
Yeah, just in terms of construction, there's a lot of discussion on the construction traffic management plan, and there's things like finding ways to bring staff to the site together and that sort of thing. I can understand that's possibly a good practice thing that you'd recommend generally. In this situation, the traffic volumes are very low, aren't they, in terms of other regions? And do you think that's a good to have thing, or is it an essential thing to have such detail, bearing in mind potential difficulties with enforcement, monitoring, all those sorts of things? Is it your recommendation that from a traffic safety and efficiency point of view, there should be a construction staff management plan or traffic management plan?
I think it's certainly best practice, because the like you pointed out, the roads are low volume at the moment, and therefore encouraging transport coordination strategies will reduce the impact on the roading network from a efficiency perspective. But in terms of I guess from a purely traffic engineering efficiency perspective, I don't envisage any problems relating to capacity on the road network. So it's something that I understand is supported by Helios, and therefore I think it should be included.
Okay, thank you. That's what I've got. Now I've understood the rest of the evidence, so thank you very much.
Thank you, Mr. Copeland. Just following on from Commissioner Ray's question, I note that the proposed condition put forward, condition 9. On 9D, Roman numeral 6. Says includes detail on how staff will be transported to and from the site, including consideration of. Is that directive enough, do you think, to be an effective condition? Does it need to be more directive? Or is that phraseology quite commonly adopted?
Yeah, I think, it's like I was saying before to Commissioner Ray's question. I think it's best practice to use transport coordination strategies with the idea of reducing trucks on the local road network. But from an effects perspective, I don't think it's absolutely essential. It's really about reducing the impact. So I think if it was more directive than that, I'm not sure what the wording would be, but whether or not it creates issues with implementing the condition, I'm not too sure. But yeah, possibly. Yeah, nothing more to say.
Thank you, that's clear. Yeah.
Thank you.
That's really good. Yeah, thank you for your evidence and for answering our questions. We'll take an afternoon tea break now. In terms of Ms. Van Heedy, what we would like to do with you is obviously if you can read through your executive summary, you may have some things you want to address us on that you've picked up during the day. Very happy for that. And then we would like to go through the conditions with you. And what we will do is once we go through the submitters tomorrow, and we'll obviously hear from planning officer, it may be that we bring you back at that stage to talk further about conditions, if that's all right. So we have got some initial comments on the conditions and some questions for you, but we may want to revisit that if that's okay. Great, you'll be here. Right, that's great. Thank you. So we will 3:05. We'll reconvene at 3:20. Yeah.
So the final witness for the applicant is Ms. Van Heedy. We're to her evidence and go through the conditions.
Thank you very much.
Good afternoon, everyone. My name is Mishka Van Heedy. I'm a senior planner with the property group, and I live in so I'm part of this district. I'm a consultant planner for Helios, and I authored the AEE as well as the application for further planning evidence. In this evidence, I've assessed the project against the Central Otago District Plan and broader statutory provisions and planning documents. I have considered the expert evidence provided with the application, the response to the Section 92 further information request, and hearing documentation, along with the feedback provided from submitters and conclusions presented in the Council's 42A report. I rely on the technical advice provided in all the expert evidence of the applicant and peer reviews commissioned by Council, and provide planning responses to these assessments in the recommending Section 42A report as outlined in Section 7 of the evidence. I address some additional effects raised by submitters under Section 8. Based on the information presented, I consider that subject to implementation of proposed mitigation measures and volunteered conditions, as recommended in the 42A report with some minor amendments and then appended to my evidence, the effects of the project over the long term will be less than minor. There are positive social and economic effects associated with the project, including supporting Aotearoa New Zealand's renewable electricity.
So can I just interrupt you there? So effects of the long term will be less than minor. When you say long term, what do you mean by that?
I'm relying on Ms. McManaway's landscape evidence, just in that she's talking about short term effects being low to moderate. And that once planting becomes established, that landscape effects will be less than.
Once the planting becomes established, that's your.
Yes.
Yeah. Okay. Thank you. Sorry, I interrupted you. So yeah, I think you're at para 1.5.
Okay. There are positive social and economic effects associated with the project, including supporting Aotearoa New Zealand's renewable electricity generation and decarbonisation targets. The project will increase the resilience of the country's electricity supply and create regional employment opportunities during construction and operation. The project will also allow for an ongoing agricultural co-application of sheep grazing. I considered the temporary adverse effects on the surrounding persons relating to landscape, visual amenity and rural character prior to the proposed landscape mitigation being established may be more than minor. These adverse effects will reduce to less than minor once the mitigation planting has been fully established, approximately 2 to 5 years. I consider the adverse effects relating to construction effects, dust, noise, vibration, sediment and traffic during the construction and decommissioning stages of the project to be less than minor or minor. Although being a matter raised by submitters, these matters have been sufficiently mitigated by design and proposed conditions in a temporary nature. The project is consistent with the objectives and policies of the district plan and the Otago Regional Policy Statement. It is also consistent with the National Policy Statement for Renewable Electricity Generation and the National Policy Statement for Highly Productive Land. In respect of the NPS HPL, highly productive land, the proposed solar farm activity is not considered to be an inappropriate use or development of the limited amount of land classified as highly productive within the site. I generally agree with the intent of the conditions proposed in the Section 42A report, subject to the minor revisions discussed in Section 7 of my evidence and attached as attachment A. Need the consent. So that's just my executive summary. I did just want to touch on what previously discussed the HPL aspects. So in my evidence, I conclude that the proposal meets the exemptions within 3.92JI. So in the HPL, so I'll just bring it up. That's the protecting highly productive land from inappropriate use and development. The use or development of highly productive land is inappropriate except for at least one of the following applies to the use or development, and the measures in subclause 3 are applied. So J is.
So what's the clause again?
3.9.
Yep.
And then 2J.
2J. Yep. Thank you.
It is associated with one of the following, and there is a functional or operational need for the use or development to be on the highly productive land. So I consider that I applies there. So the development of specified infrastructure applies to this, and I've previously gone into functional or operational need, and that's been discussed by council as well, but I'm happy to answer any questions there. And then to your question earlier about sheep grazing and how relevant that is, I don't think it's relevant to that section of the HPL, however, it is relevant to 3, which is the clause below. So that's where territorial authorities must take measures to ensure that any use of development on highly productive land minimises or mitigates any actual loss or the potential cumulative loss of the availability and productive capacity of highly productive land. So in my AEE assessment on that section and the concurrent use of the solar farm with sheep grazing is a factor that contributes to minimising the actual loss of highly productive land, along with avoiding some areas of class 3. So I think there's 10 hectares that's avoided completely in terms of the footprint of the solar farm. And then, the eventual long-term remediation of the site. So the current sheep grazing is a factor that contributes towards the minimisation of the loss of productive availability. And council mentioned is the availability that's important there, not it has to be sheep raised for sheep. So,
and do you know what the expected reduction in stocking rate would be? No. Okay.
The scale of the proposal. We'll just briefly touch on this. Yes, it's big. I don't think there's any denying that it's big. But the benefits are commensurate with that in terms of its generation potential. And even with the scale of it, all of our experts and then even the peer review experts as well all conclude that effects subject to appropriate conditions are acceptable. And it aligns with national direction. Just a quick touch on piling. So we had a quick chat with Helios earlier, and as a conservative measure, they would anticipate the piling aspect of construction to be closer to 9 months, not the full 24 months period. I'm not proposing that be restricted to a condition of consent based on the acoustic evidence that it's well below those standards anyway, but just to give you an idea of the anticipated sort of nature and scale of the construction.
And do you know, or someone might be able to help us, you'd anticipate that the piling would all happen at the same time?
But move throughout the site.
So that it'll all be done together, yes. And then, so that's around about a 9-month period, and then it'll be done and finished with the piling. And that's the most noisy aspect during construction.
Yes.
Yes. Yep.
And then got a few other things to say, but they're more in relation to the actual conditions. So I might just start going through those.
Well, we might ask some questions of your evidence and then we'll get to conditions.
Yeah.
So if that's all we have there. So I might start at paragraph 7.10. And you may have covered this further down, but and feel free to direct me to where you have covered it. Do you have an understanding of what other resource consents are expected to be required from the regional council?
Yeah, at the moment, the only one that we know we need is under the NES, which is clause 45(2), which is a discretionary activity. There's a possibility during detailed design that other aspects might need consent. It's not looking likely, but
So sorry, what's under the NES for freshwater?
oh, sorry. So the standard is that it's a 10-metre setback.
Oh, that's the wetland setback.
Yeah.
Okay.
So that's what would be breaching in some of them. So we need to apply to the regional council to hopefully obtain consent for that breach.
And at this stage, you're not aware of any others?
No.
Okay, thank you. And do you think from a planning perspective that there would have been merit in bundling those two applications together?
Yeah. One of the reasons that it wasn't is because we're not going to know for sure that we don't need other regional council consents until the detailed design stage. That's probably the main reason. Yeah. Sorry, dewatering would be the one, so we don't think we need it, but there's a possibility we might.
Yeah. So in terms of paragraph 7.23, and this is the functional operational need issue under the NPSHPL. So you've said I've included both operational and functional needs in the list below, and you've listed A through to F. It would be helpful to understand which are operational and which are functional. I don't know if you want to do that now or whether you want to come back to us.
Draft. I started off doing that, and then I bundled them in.
Yeah.
I might see if we can just write that with them.
If in writing, that'd be great. The one that replies fine. That would be great. Thank you. I'll make a note of that. Yeah.
While we're on that paragraph 7.24, in your second sentence there, you've said while the functional need aspect may be debated, does that mean in your view it is debatable, or are you uncertain whether it meets functional need?
I consider it meets both functional and operational needs. The debated is more in reference to a reporting officer disagreeing with the tier.
Sure. It's paragraph 8.5. So I'll do all my questions and you may have to zip back up for the other commissioners. Apologies in advance. So there's a proposal to underground the lines, and you have addressed that in your evidence about, if there was if they, that's the proposal and that's what's in front of us. So if the applicant decides in future not to underground the lines for whatever reason, do you think that could be dealt with via a variation of this consent, or would it be a new consent that's required?
At first glance, I'd consider a new consent as being required, but I haven't fully been aligned to that.
And does your conclusion regarding effects rely on undergrounding those lines?
I haven't made a conclusion on effects of that aspect because that aspect doesn't require resource consent.
The undergrounding, did you mean, or if they were over?
Yes, well, I haven't considered effects if they were overground because that doesn't make up part of the proposal. And then my understanding, the undergrounding, that aspect does not require consent.
Right.
So
yes,
yeah.
Okay. Yeah. That was, yeah.
And on a similar vein, if the battery storage system was brought back, would that likely be a variation or a new consent, you think?
I'm not sure.
So-
Probably a question for council.
Yeah, I mean,
I could see an argument either way. And probably the end result is similar in terms of the level of scrutiny required.
I mean, it's not in front of us, but if it was to be lodged later, it would, the potential consent here could form part of a receiving environment, and but that's by the by. It's,
I think if you do it as a variation, it's discretionary activity anyway. If you do it as a new consent, it's still a discretionary activity and you're using the existing. I think you end up in a similar.
Still discretionary. Okay.
You mind if I respond?
Oh, sure. Yeah.
My first reaction to that would be, I'd say new consent, primarily on the basis that there's no petrol storage, there'd be no condition to vary, that there'd be nothing to vary in this consent.
Right, but it would still be a discretionary activity in your view?
I would say it would be because it'd be part of a project measures.
Okay.
I'd agree.
Anyway, it's a hypothetical, Thank you.
And then at 8.6. And you've talked about the second sentence, the proposed decommissioning plan does not include the removal of any planting. The conditions, as I read them, essentially require the planting in place for the term of the consent. Do you think that's appropriate, or do you think they should apply going beyond that?
I think it's appropriate that they are tied to the term of the consent. I mean, there is no plan to remove them, but a future.
Like in terms of maintenance or?
No, there's no requirement to maintain that planting beyond life.
Yeah, and that's not necessary.
No.
From a planning point of view.
No.
Okay.
Paragraph 835, you address the matter of a bond. And we have discussed this earlier with legal counsel and Mr. Schlichting. And you've stated here from a planning perspective that you do not see such a condition providing any meaningful environmental benefit. Are you saying that from the perspective of a general planning perspective, or do you have, given your experience working in this district, have you had direct experience with how a bond is applied within this district?
Yeah, I guess this application, at first glance, it's a big application, you think immediately bond, but it's not altering the landform like an open cast mine or a hole in Queenstown. I don't necessarily think there's a strong planning argument for it, particularly given Mr. Schilting's response in terms of it's already essentially provided for. I'm less able to comment on council surety and comfort over that.
In terms of the mechanics of the actual bond mechanism, are you familiar with how the Central Otago would apply it?
No, I haven't dealt with the bond aspect with this council.
Thank you. That's something we'll check with. Thank you. We have one more question.
Yep. Oh, it's still on board.
Not on board.
Okay, I might just just following on, from Commissioner Day Cleveland, when you're talking about it's not providing any meaningful environmental benefit, that's still at 8.35. I guess the question I have in my mind is if the applicant isn't able to complete the works or the remediation plan for any reason, wouldn't a bond ensure that the environmental effects and therefore the outcomes planned by that remediation relied on by the applicant's experts be achieved? Wouldn't that be an meaningful environmental?
Yeah, if it wasn't for the mechanism already provided through the insurance and the banking that requirements that Mr. Schulting was addressing earlier, then yes, that would be a concern. But I think that I don't think a bond on top of that provides any meaningful.
But we don't have any. There are no conditions requiring insurance or requiring a bond as part of his landowner agreement.
Yeah.
So from a consenting authority perspective, and therefore ensuring the effects that are to be mitigated by those aspects, what's the surety from council's point of view that they will be carried out?
Council may want to weigh on this later. I think practically it's covered by it, but I see your point that council doesn't necessarily have any surety over that. Potentially there's a way to avoid doubling up on costs, but somehow link. Yeah.
Well, I can put an idea to you.
Yeah.
Well, I mean, the conditions that, I mean, they're the way the conditions as I read them, they do require the remediation. And so it's not an optional extra for the applicant. They would, the consent holder, they would have to meet those conditions. So would it in fact be a compliance issue for council? You could, is one way to look at it to say, well, it's a compliance issue. And therefore we would, it is expected and required legally that they comply with all those consent conditions.
Yes.
But presumably the alternate position to that is, well, this is a very long term, this is a 35-year term. It's a long time to rely on compliance of conditions. I guess I'm just sort of putting both sides of the argument to you, and whether you have any views.
The requirement to adhere to your conditions of consent is just as true the day after you issue a decision as it is 35 years down the track. So I think that requirement, that same legal consideration stays.
Yeah. Okay. Yeah, I'm sure we'll hear about that in reply.
Yeah.
Do you else?
Yes, just one more question from me. You would have heard me talking with Dr. Morris, Mr. Morris, around the offset language or the phraseology that Mr. Vincent used in his Section 42A report. And I was wondering, from a planning perspective, have you picked up on that or contemplated that in your assessment? And what are your views there in terms of what it represents?
I agree with Dr. Morris in that in this instance it's not offsetting, it's remediation. And in some instances it's a benefit rather than direct mitigation.
So a positive effect.
Yes. Yeah.
Okay, thank you.
No, but
Okay, that's all we have. So we'll just go through conditions. Do you want to talk to those first, or is there anything?
I've kind of just drawn the emphasis and gone on each of them. So maybe if you just interrupt me.
Well, why don't we, do them in order?
Yeah.
So
there was
a bit
one-
laborious.
Yeah. There was one mention of the community benefit that was outlined in Jeff's evidence, and you questioned whether that could be a condition of consent. We have no issue with that. I believe Sarah has some examples of similar consents that have linked that in, so we can provide.
Thank you.
Yeah, and then again with the accommodation details. Commission suggested that be weaved into the traffic management plan. Sorry, the construction management plan, similar to that of the how staff will be transported. Again, we have no issue with incorporating something similar in there. I'll start from the top and then we can.
And just before we do that, I just wanted to re-emphasise for those in the room, we are talking detail and conditions. That is not because we have any view about whether the consent will be granted or not. It's that we need to be clear on what the conditions would be if we choose to grant. So just to be very clear on that for those who are here listening. Thank you.
Condition 1. So the only tweak to Adam's condition there is just clarifying that that first plan A is the updated version. 2, the only tweak there is just to be slightly more concise condition wording.
So I have a question on 2. What happens if the plans are not certified by CODC?
Then we don't fulfill that condition and we have to keep going back to CODC to get certified.
Okay. So do you see the need for any other? I've seen other large construction projects where there is a condition around a little bit more detail about how that certification process would work. Are you comfortable?
So the certification of management plans is sort of 5 down to 7.
Yes.
And are you concerned that they're not sufficiently detailed?
No, I think they're actually well crafted. So the condition 5 says a minimum of 40 working days prior to commencement, which is generous, I have to say. And so you have to provide it to council, and then you go through a certification process. Yeah, I'm just checking that you're comfortable with that. I have seen other conditions where there's if it's not provided by a certain time, or if, provides a sort of an out there, but you might be comfortable that that's not necessary.
Yeah, there was a phase where there were those sort of deemed certification provisions. The Environment Court has weighed in
Said no.
certain divisions and said no to that. So we steered clear of that. There is, I guess, a degree of applicant or consent holder risk and not having something like that, but it is something that the certification role, the Environment Court has also been clear that that is quite a limited role that the council has to make sure that a management plan meets the objectives of that particular condition and contains the various requirements outlined in that condition. So
it's a checking as opposed to
correct. It's not a delegation of responsibility down the track to the council to make their substantive decision in relation to the management plan.
Thank you.
Just what on condition 2, that's the link to all the management plans. You have to observe those plans. And when we come to condition 28, just when you get there, that seems to be a double up, but I'll just park that for now, but just keep that in mind.
Yeah, the reason.
Oh, there's a reason.
Yeah.
Okay. Oh, good. So it's good. Okay.
That can be
Very good. No, thank you. Yeah.
3, no changes to condition 3. It's a really standard one. 4, legal counsel has sort of addressed that. So unless there's any questions, we'll move on. The certification of management plans, that was sort of drawing on existing drafted conditions to try and consolidate that process a little bit.
Sorry, back on 4. It's just more of a suggestion actually for me that the plans might want to think about. Presumably you'd need some sort of notification clause in there that the consent holder would need to advise council of that. So because the term is quite important about when it starts, therefore when it finishes.
Oh, she's going to,
Thank you.
Cool.
So the certification of management plans, that's just sort of bundling that all in, with the exception of condition 28. So we get to that later, but essentially the short story is that was developed at the 11th hour with Doc. with managing a few staff absences that docked to it. So yeah, we didn't want to then open the structural issue and trying to incorporate it back in to be consistent with that. We just wanted to bring in that we have no issue with that structurally changing as long as the content doesn't change, given that docs approved that version of consents of conditions.
And so back to 2, well, there's something not quite right there for me, but just a suggestion to consider for you to come back to us on is, I think you need to list the management plans or at least cross-reference them to the other parts of the consent. You've sort of got with all management plans submitted to. I just think there's a that needs to tighten up a little bit.
And on that as well, condition 5 lists does link to some of the management plans, but I know that doesn't link to the glint and glare plan or the bird monitoring plan, I don't think. So you might just want to see if that's.
There are different timeframes for them. But
yeah.
Thank you.
And then 8, this is just to streamline the conditions. Any questions on condition 8? And then
I think 8 needs to link to conditions or the management plans you're referring to, or some sort of connector. Yeah.
Construction management, so the strikeout text there is because we provided it in 5 to 8 above. And I believe most of these details have been discussed with Transport already. The clarification that heavy vehicles don't use Ranfurly Back Road, but other vehicles can. And then the staff transportation, so that's where we could incorporate the staff accommodation in a similar vein. Sort of wording there. You had talked about whether or not that BI was directive enough. If the panel was of a mind that it's not, keeping in mind the transport evidence that he actually wants it to be a bit looser, you could just delete consideration of, and that would make it a bit directive. Cool. One thing is the addition of G as requested by Karunaka. G doesn't exist anymore, so that should say F is what that condition is there for.
Could you just hold for 1 minute? I'll just take a note.
Well, we're on the heavy vehicles. I just recall in Mr. Copeland's evidence, he had deferred an aspect of management to you around the curfew for heavy vehicles. Is that relevant? A relevant matter here? We didn't discuss it today, but I recall reading it in his evidence that he had deferred something around a curfew to.
If it was deemed necessary, by you, yeah. Yeah.
I might leave that for a right of reply. I just want to have a little bit more of a think about it. Just in terms of I think it's probably going to be resolved by the construction times anyway, but
So which paragraph was that?
8.12 of Mr. Cochrane's evidence. Specifically said, I consider that setting curfews for heavy vehicles is not required to manage transportation effects, but I acknowledge it may be desirable to do so for non-transport related reasons such as amenity. I therefore consider this is better addressed by the project plan. Just want to have a bit more thing.
That's fine. Oh. I'm keeping it. Yeah.
Then the erosion sediment control plan, so the deletion, again, it just relates to that already being, dealt with certification conditions. Again, that deletion about it being amended is already dealt with previously. Same with 11 or the previous 11. Yeah, and then there's just some clarification of condition wording there.
The next question I've got is for 18A. Romans 2. And this might be a question for possibly the ecologist, but you've got, including in this is the landscape management plan, which needs to include some things. And you've got details of irrigation or water retention provision for 2 years after implementation and availability if required through dry summer periods up to 5 years after implementation. And again, you may need to refer to your experts on this, but the question I had, does that provide enough certainty that we're going to see the growth rates that are expected by those experts and therefore their conclusions around effects?
Yeah, I think I would then refer you to 19. Sorry, not 19. 20, where we need a minimal plant survival rate of 80%. So regardless of what irrigation is required, if we don't meet that 80%, then we're not in accordance with our conditions of consent.
Yes. Okay.
Is there any questions before condition 18?
And sorry, again, this again might be for somebody else, but this is our last opportunity with your team. Where do you expect the water to come from in terms of irrigation?
So the options outlined in that landscape planting and maintenance plan talk about the provision of appropriate measures to allow for that plant maintenance. And so specifically they talk about water retention crystals, which is through that peer review process. And that was undertaken on the plant list that they raised that that's a viable and workable option in this environment. And so moving forward, that will be the detail that comes into that detail with the plant and plan. You are looking at the exact species spacing and any measures required to provide for their health to meet that 80%. But just flagging really that we have that advice that water retention crystals are appropriate in this environment. Given water takes and water used generally in this environment, as soon as it's a dry climate, that's an option that we really want you to understand. So that's
and where did that advice come from?
That's from the landscape planting maintenance plans. That was the peer review process.
That's right. Yeah, thank you. And so is that your intention? You will rely on the crystals as opposed to other sort of irrigation?
That we want to address that fully in the detailed planting plan and understand as we work through that process and get the planting, what is the best approach to allow for that plant health and management that we're after. It's just so we can flag that water retention crystals would be an appropriate measure. Yes, we really know that
Okay, thank you.
A lot of the following changes have been addressed in the fire risk discussion earlier, following on from the these are parts of condition 18. And then again, the local seed sources have been addressed in previous evidence.
In terms of 19, solar farm is operational. I think there's a condition earlier that it relates to term. Have you used the same terminology there? Just maybe just check that, what operational means. And also, is it clear what implemented means?
To me it is, but we can.
So that's
put in
all of the
in accordance
planting
with the-
complete?
Yeah.
Yeah. I think you would need some more detail on that.
Okay, so it's condition 3, where it says, operation date being the first date the project is commercially exporting power to the national grid, excluding operations under test conditions.
So maybe cross-reference up to condition 3, yeah. And then, as I say, the implementation of the mitigation plan, because the plan requires planting, but then it requires maintenance. So I think it would need to be clear what do you mean by implemented in terms of that condition.
The note to condition 18 refers to the word compensation planting. So you might, just given our discussions and your confirmation that we don't have an offset being proposed or a compensation being proposed for continuity, consistency.
So at the note to, oh, yeah, sorry. And then condition 20, survival rate we discussed earlier.
Yeah.
Which just better aligns with the landscape planting and maintenance plan. And then again, the condition 21, I just wanted to be more specific on what that's referred to.
Must be a number missing off the bottom one. It should be 22, shouldn't it? A separate condition, isn't it?
21 is all shelf belts must be maintained to a minimum.
Yes. And the wording underneath it.
Oh,
Yeah. I missed a number, that's all.
oh, yes, yeah.
Yeah. Right.
And just if not stuff, so we'll obviously be asking council's experts around the condition 17 that's being recommended to be removed. Regarding the survey work and so on. It's late tomorrow.
Yeah, the wetland enhancement conditions is in relation to our workers' stock. Yeah, so the lit review we've talked about quite a bit with Karen earlier. Was there any questions?
On that note, I signal that you've got that one covered.
Yeah, I have no issue at all with that, better aligning with the other management plan conditions. It's just making sure the timing's sorted.
Yeah, because it uses the word shall and it reads like a condition, that's all. Yeah.
Oh, the note. Oh, yes. So I actually did look at this.
Okay.
So I think most of that is already incorporated into the condition. The only thing that I think hasn't been is the input from a moulding expert as identified by Carlin.
Right.
Okay, so I think that could be incorporated.
That could be elevated up, yeah.
But the other aspects
Right.
are already
Already in there. Okay.
Yeah.
Yep.
these have been addressed quite a bit through the,
Yeah,
articles.
I think we can keep going. The next question I've got is 30. You don't got anything?
Wetland and.
Yeah. No. And in fact, the question relates to, so just cast your eye over the middle of 30 where you've got any review comments from DOC, including any response to comments shall be appended to the wetland management plan. So that, just have that in your mind. And then in relation to condition 32, which relates to the fire risk management plans being provided to FEN. So the last clause, the paragraph of condition 32, you've got these plans shall first be provided to FENS for review and comment, and any comments received shall be addressed prior to submitting to Central Otago District Council for certification.
Yeah.
A few niggles in my mind around that in terms of, obviously we need to be careful we're not providing any sort of authority to a third party. And so how would you see that condition working in practice? What do you mean by addressed?
Yeah.
And I'm just wondering whether the wording you had for condition 30, I think it was, 30, around the comments from DOC is a better wording in terms of certainty of compliance with that condition.
I agree.
Yeah. So it's essentially you need to take on board their comments and you need to say, well, this is what we've accepted and this is what we haven't, and this is why. Yeah, okay, thank you.
And,
Yeah.
we've skipped over 28. Sorry, you were going to comment on that one there. So, it appears to duplicate condition 2, but you said there was a reason for it. So, yeah. 28.
Yeah, that was just because we were really skirting the evidence timeline, and we needed to get DOC to agree, and we didn't have time.
Oh, that's a DOC condition, is it?
Yeah.
Oh, I see.
So it wasn't that there's a specific reason we don't want it to be matching the same wording.
It's a belts and braces type.
Yeah.
Okay.
It was just this was happening in isolation while the rest of the conditions were being tidied up.
Okay.
So if we decided that it was better to combine those together, there wouldn't be any reason why.
No, I just would want to make very sure that the conditions still achieved the same as this, because this is the version
Freedom
of
of thought, understood, yeah.
What are we up to now?
32,
So
33.
33.
Oh, I had a question on 31. So the consent holder must prepare and implement. There's no mention of certification here. Is that an oversight, or is there a reason why that wouldn't be submitted like the other management plans for certification?
Oversight.
Okay. Yeah.
So
And
is it, sorry, I think, so the condition at number 3-ish, doesn't that say they will have to be filed and certified, and these are certified?
Yeah, because state cross-reference.
Yeah, I think there's some tidying up to do with all of those,
Yeah.
just to make sure you're not,
Yeah.
okay.
No issue with that.
Yeah.
And then just a minor observation that there's a change from affected parties to complainants, but the word affected parties is still used throughout that condition.
Okay, so the reason we prefer to use complainants is that affected parties is section that, yeah, and we want to be very clear that they're not affected until formally.
Sure.
So
So that's 31C, you'll change the wording there, is that what you're saying?
B, C, D,
So you'll change all of that, yeah.
yeah. Multiple instances.
Yeah.
Yeah. And 33,
yeah, I think. But I've got a scrolled comment here from one of your earlier questions. Weather fences, highlighted issues of being effectively incorporated into the condition. Like G across the next page, has a lot more detail.
Thanks. Hazel.
The size, location and details of the fire water tanks.
One of the questions I had relates to the fire breaks mentioned in Mr. Denise's evidence and whether that's specifically mentioned. Was that just in relation to the boundary?
The fire breaks are shown on the updated layout.
So that on the layout,
Yeah.
so that covers.
And F.
Oh, F has. And so the access tracks are this, sort of is the fire break.
Yeah.
Okay, thank you.
And the perimeter access
The
tracks.
perimeter. I just wonder if that needs to be specified in case they were changed or something in the future for some reason, and then it's not clear that they are required for fire break purposes.
Yes.
Something different noise. Yeah.
Do it for 35. I do have just a quick tweak.
Yeah.
Towards the end of the condition, or the very last line of the condition, it talks about a meeting every 2 years. So that updated Fenn's email correspondence that was talked to, I just had a chance to review it.
Yes.
And they had questioned whether that could happen every year. And we confirmed back to them, yes, that's fine. We haven't had a response, but we're happy to change that condition
To
every
annually.
1 year. Instead of 2.
So annually, yeah.
And we can provide that correspondence.
Yeah, that's
a pretty term.
Thank you. Please do.
Don't have any other scrolls over any of them. So.
Okay.
Yeah, no, I think I was going to ask a question about 38, but I think I understand it now. That's the noise. The noise is applied at existing dwellings or consented dwellings at the time of the issue of consent. So if a landowner on a neighbouring site wants to build another house closer to the boundary, that's not the noise levels won't apply to that new house, will they? Because it's at the time of this consent, if this is right.
Yes, though I would imagine from the acoustic evidence that because there is a bit of a buffer, it's fine anyway. But no, yeah.
I did, I just record here. I did mean to ask Mr. Ibbotson that question, and I forgot to do that. So, if there's any opportunity to ask him if one of the neighbours decided to build a house right on the boundary or 5 metres away or whatever it was, would he have confidence that the noise levels would still comfortably be met at that location? Because all his evidence was geared at existing houses or notional boundaries, but I don't know the answer. So if we have a chance to put that question to him, I'm happy to write it out, but that was the gist of it. Because that condition as it reads would not protect landowners from a future house, as I read it. Yeah, okay.
Mr. Manhinnock, do you want us to write that out, or are you able to put that down?
I've got notes of that. And
Yeah.
so with it just being incorporated.
In the reply,
That would be fine.
Yeah.
From Mr. Ibbotson as well.
Okay, thank you. Thanks.
That's all the questions we have. So if you had anything else?
We've covered the wetland aspect quite a bit.
That's all. Great, thank you.
Around.
Yes, thank you very much for your work, and that was a bit tedious for everyone listening, I'm sure, but I really appreciate you taking us through those. So, Ms. Manhinnock, that's your case.
That is, thank you.
Thank you. Thank you very much, all your witnesses. Much appreciated. So we will adjourn for the day. We are scheduled to start again at 9:30 tomorrow morning. The way the day tomorrow will look will be running through in order of the schedule that we've got in front of us. I've been advised that I've got an extra submitter who would like to be heard. That's no problem. We can accommodate her. In terms of timing, we will see how we go. Because there hasn't been any evidence pre-circulated from submitters and we have read your submissions, it's my expectation that each of you would spend about 10 minutes with us. If you feel like you're going to need longer than that, I may have to raise that with you as we go, because you're not able to raise anything that's not in your submission. So just to let you know that around about 10, I'm not going to say 10, you have to sit down, but I would have thought it's unlikely that you'll need to spend longer than that for us to understand the issues that you've raised in your submissions. In terms of things that you've heard today from the applicant, absolutely fine to provide any feedback or comment, particularly around conditions. If you have any feedback on that, really happy to hear about those. But in terms of the schedule, we'll just run that through. We'll see how we go for staff. If we have time, it'd really be great to finish tomorrow. And we will come to some questions. What I would expect from you and your team is a very brief summary of your report, particularly in light of what you've heard from the submitters by then and the applicant's team. It would be really useful for us to know whether anything you've put in your report has changed in terms of your recommendations or your assessment. And then what we'll do is have another opportunity to talk about conditions at that stage. What is quite likely, I suspect, is that we will send you off to, perhaps as the planners do, a bit of, not necessarily conferencing formally, but at least a bit of back and forth on the conditions before you come back in your reply. But let's see where we get to on that. So is that suitable for you and your team? Great. Site visit. So our intention is, if we finish tomorrow, we'll probably be losing the light, and so we will probably do a site visit on, what is that, Thursday morning. We've had one neighbour who's requested that we visit their property. That's no problem. Thank you for that. We're happy to do that. Just to let you know, we won't be able to talk to you on your property, so please don't come out and greet us, as much as that's very, I know that locals do like to do that, but we're not able to discuss anything with you. So we'll just literally drive in, have a look around and then leave again. We're not able to have any conversations with you at all. So if there's anybody else that would like us to visit their site in relation to this site, then please let Taryn know. But otherwise, we'll assume that we've got that one neighbour to go onto that private property. Otherwise, we'll talk to you. We'll get Taryn to confirm with you around visiting the site on the site. And I understand the landowner might be able to give us a drive around. Again, we won't be able to talk to them about anything in relation to the case. So very kind of them to give us a drive around. Now that we've seen the site, we realise the vehicle on site would be useful. It's the scale is large. We would like to have a look at the wetlands in particular, and the planting areas and things. So it'd be great if someone could drive us around. But as I say, we won't be able to discuss, as you know, the case at all with them. So I think that's also at this stage, we'll look for Thursday morning to do that, or if we end up having staff on Thursday morning, if we run through tomorrow with the submitters, we'll do it after that. So is that an issue from access timing point of view? Okay, great. Yeah. Yeah, great. Thank you very much, everybody, for your attendance today, and we'll reconvene at 9:30 tomorrow morning.
Cool.